This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, reading through the Menendez brothers' 1996 retrial in the homicides of their parents, Kitty and Jose. And we are on the defense's case, part 73. We've got a lot to do today. So, first, we're going to finish up some heated arguments about the molestation evidence coming in about Lyle or from Lyle, because he's not testifying. So, of course, it's going to be difficult getting it all in. And the judge and the prosecution seem to be trying to work together to keep it all out. At least that's my opinion. And we're going to continue reading on. So they'll finish their arguments. The judge, I believe, will give a ruling, and then, but don't quote me on that. And then we're going to finish up with Brian Andersen Jr.'s testimony. We've got some redirect continuing. And then after that, Diane Vandermolen is going to go on the stand. So that answers that question. Diane Vandermolen will get to testify, but what does she get to testify to? We're going to listen to these arguments first to find out. Before we get into it, I would like to thank my founding justice insiders, Toyota Girl 67, SLB 29488, May the Force Be With You 4313, Jessica Wienand 6079, Mrs. Apples 2007, Butler 89833, Brooke JF, Jen P 773, Boom Chicka Wow Wow 1, and Kendall B 5757. Thank you all for being founding Justice Insiders. You can also be a founding Justice Insider if you join my membership tier of Justice Insiders, and between now and today. Today is your last day to join. I had to look at the calendars when this is airing. Today is your last day to join to become a founding Justice Insider. So if you were thinking about it, act now. You get your name read on screen and immortalized in the member wall of fame as a founding Justice Insider. Okay, so let's now talk about the case today. So, just so I know, we've got about 160 pages to read through. So, let's get started. Um, so this is going to be the morning of, I should say, Wednesday, January 17th, 1996, the 9 a.m., and we're all present. The following proceedings were held in open court outside the presence of the jury. We're going to start coming in hot with arguments, okay? So the court says the defendants and counsel for both sides are here without the jury. We're ready to resume with the hearing being conducted yesterday. Mr. Levin says, before we do that, may I address the court regarding the Park Dietz matter? I think the court has to be aware of, and the prosecution needs some time to perhaps make this visit occur. The court says, let's get to the issues here and then we'll do it. Ms. Abramson says, I also want to address the court on that issue. We're going to be asking for a hearing before the court says, let's deal with what I said we were going to deal with, what we were doing yesterday. Ms. Andersen says, we're trying to add to your agenda. The court says, that's fine, but let's focus on what we were talking about yesterday. I see some transcripts here, and they are. Ms. Towery says, yes, Your Honor. I can focus the court on the specific portions. Sometimes there are additional pages in some of these transcripts to put it in context. These are instances in the testimony of Erik Menendez in which we believe that he testified to the molestation of Lyle Menendez without objection and that the evidence came in substantive evidence of the molestation. In volume 260 at page blah, 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 because I'm not reading the page numbers anymore because they're just too long. Page number blah, blah, lines 1 through 24, Erik Menendez talks about the ride in the car to San Diego and indicates that Lyle Menendez told him when Erik was explaining to Lyle the details of his own molestation by his father. Lyle told him that it had also happened to Lyle for a period in his childhood, and that's at lines 21 through 24. In volume 265, pages blah, 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 Erik Menendez testifies regarding Lyle Menendez's reluctance to talk about the molestation, and at these other pages, lines 23 through 27, he discussed things. He mentions again that he discussed with Lyle Menendez the things that happened with their father. The court says, "What line is that?" Ms. Towery says, "That's at blah, blah, lines, blah, blah." He's referring again to the discussion in the last week in August with his brother Lyle Menendez regarding the molestation, things that happened with his father. That's not as direct a reference as the first citation. The court says, okay. Ms. Towery says, volume, blah, blah, is the next reference with these lines and page numbers. The court, Mr. Khan says, I'm sorry, could we have those again? She gives it again and says, Erik Menendez testifies regarding Lyle Menendez's reluctance to talk about both boys' molestation, and that he was not dealing with his own molestation. And Erik wanted him to come to terms with that, and that was in the context of Erik Menendez's testimony about the Brian as Laminia letter and how it came about. The court says, well, isn't this just a reference to the state of mind of Erik Menendez? It doesn't say what it was that Lyle Menendez said. Ms. Towery says, he's already testified that Lyle Menendez told him about his own sexual molestation, and then he testifies at numerous other occasions about discussions with Lyle Menendez regarding Lyle Menendez's reluctance to disclose his own sexual molestation. Now, the testimony of Erik Menendez indicates that Lyle Menendez's reluctance went towards the molestation of both brothers, not only his own, but focused in large part on his own shame and inability and desire to disclose the fact that he himself had been molested. That, in particular, this passage refers to. She's reading some other lines and says, again, Erik Menendez testifies regarding Dr. Oziel and his desire that the molestation in general, in his own molestation in particular, was not to be discussed with Dr. Oziel. Then, in another citation, Erik Menendez testified that during an incident of sex with his father, in which his father became angry, his father started slapping him and said, "Why can't you be like your brother? Why do you always have to cry? You're good enough to be you're good enough to be a Menendez." Ms. Abramson says, "You're not good enough." Ms. Towery says, "You're not good enough to be a Menendez, excuse me." Now we've got some other citations. She goes on to say, I'm sorry, I failed to mark that. That's the last in the packet, but it is, here's the citation. Erik Menendez is discussing, this is the bottom of the page. He's discussing the December 11th tape and the portion of that tape in which he says Erik Menendez says that it was ruining his life. And he guessed Lyle's, and he explains that that's where Erik was talking about the molestation. And he also said, I guess Lyle's, because he knew that it had happened to Lyle in the past. And that's at line 1 and 2 at page blah, blah. There are many other instances in which Erik Menendez referred to sexual molestation, but the references were not as specific in the references to Lyle Menendez's sexual molestation. There were more generic references, so we did not provide those to the court. These are the more specific references that he did make, in which he testified that Lyle Menendez was sexually molested when he was a child, which testimony was never objected to by the prosecution. The court says, and the offer of the statement from Lyle Menendez to the next witness is to prove that a molestation had occurred? Ms. Towery says, well, Your Honor, it's offered on two bases. The court asked that I conduct some further research in the area of fresh complaint last night, which I did. And in doing so, I discovered that the California Supreme Court considered the issue, and in People versus Brown in 1994, and the citation for that case is blah blah, and in the Brown case, in essence, what the California Supreme Court did was consider the continued reliability of the fresh complaint doctrine and decided that, in essence, they decided it was too narrow because it was based upon a historical belief that a victim of sexual molestation would normally or naturally promptly report it. And the court discussed recent studies and the recent knowledge, which indicates that that is not the case when one is dealing with sexual molestation. Therefore, the California Supreme Court stripped the doctrine of the requirement of both freshness and the statement having been volunteered, as opposed to being provided in response to questions from the doctrine because of modern knowledge. It did, however, hold that such evidence would be relevant in most cases as evidence which would assist the jury in coming to a reliable determination as to whether or not the claimed offense or the claimed molestation actually occurred. And the evidence of the complaint, including the circumstances under which it was made, in most cases would be relevant. So I withdraw it. Based on the Brown case, I do withdraw my offer yesterday afternoon of the evidence as for the truth of the matter under the fresh complaint doctrine because I believe that even though the Brown case did not overrule previous cases, and just in response to the court's inquiry yesterday, the Meacham case did rely upon the fresh complaint. It's sort of a convoluted fact situation that there was only the evidence of touching with respect to at least two victims in that case. And despite my own personal reference in the argument proposed by Justice Jefferson that the courts should recognize this as an exception to the hearsay rule, as opposed to some other basis for admissibility, the California Supreme Court in Brown apparently was aware of that suggestion in Jefferson's evidence bench book since it cited it and did not adopt that and did continue to describe the fresh complaint doctrine as a non hearsay purpose for the evidence. The court says, then it's not offered for the truth of the matter asserted. Exactly, says Ms. Towery, to disabuse the jury of the notion that if a complaint was not made, then the act did not occur, which is what the California Supreme Court said in Brown and was the basis for the doctrine previously. In Brown, really, what the Supreme Court did, as I mentioned before, was just to eliminate the requirements of freshness and volunteered information from the admissibility standards. I would, however, as an alternate basis for admissibility of the evidence, I think it should come in clearly as a fresh complaint based upon the citations to the transcript that we have just provided to the court, in which direct substantive evidence of Lyle Menendez's sexual molestation has come before the jury, and as mentioned yesterday, the relevancy on that issue. But I would also offer it to the court under the alternate analysis, which Brown approves of, by the way, as the hearsay exception under several different theories. First, under Evidence Code Section 1236 and Section 791B as a prior consistent statement because, as I mentioned yesterday, an express or at a minimum, implied charge of reason of fabrication has been made by the prosecution, and this statement was made long before any such motive to fabricate could have ever arisen. I'd also offer it as a spontaneous statement under Evidence Code Section 1240 and as a statement of a declarant to then existing mental or physical state under Evidence Code Section 1250. And all of those would be offers that come before the jury for the truth of the matter asserted. The court says, okay, and what is the people's response? Here we go. Mr. Khan says, I think that the defense has clearly failed to establish that there is any evidence before the jury that Lyle Menendez was molested by Jose Menendez. If we take a close look at each one of those references, what we see is a total distortion of what was being alleged yesterday. Yesterday, counsel said that Erik Menendez said that Lyle Menendez said he had been molested by Jose Menendez. And today we looked all night for it. We couldn't find it. And today we come to court and we see we have vague references here which totally contradict the false representation made by counsel yesterday. At page blah blah, he told me in vague terms some of the things that had happened to him with dad, that it had also happened to him for a period in his childhood. What things? It's never explained what he means by that. What things? So it is not before the jury in that passage. If we turn to another page, we have him talking about those things with him, and I have never personally had a conversation with him about what he did to me when I was a child and the things that happened with my father. We discussed that the last week in August, and I don't specifically remember any of the other conversations that we have had where we have discussed it in detail since. Discussed what? Again, we have nothing more than a vague reference. Counsel can't, but you have to take into context what they were talking about before in the sentences and paragraphs before that. 'Cause if they were talking about that, then it's implied. Again, we have nothing more than a vague reference. Counsel cannot rely upon these vague references to argue that Lyle Menendez said that he had been molested by Jose. Then we get to another page where it says Lyle was not dealing with the fact that he had been molested. Well, what does that mean? Erik Menendez is assuming at this point that he had been molested, and molested by who? Isn't the critical inquiry who? Who molested him? This could very well be, based upon what he revealed here, this could be an assumption by Erik Menendez that Lyle Menendez had been molested by somebody, but we don't have a clue who that somebody is. We just have the assumptions of counsel and her sneaky reliance upon the testimony from the first trial, which is what she seems to be relying upon without expressly saying it. On another page in that context, yes, he was saying, listen, we don't have to go with this. We don't have to say that dad molested us. We can go with something else similar to what you said about how, once again, it is not a clear empathic statement that Lyle Menendez said that Jose had molested him. The conversation here relates to what they are going to discuss. We don't have to say this. It never says that it truly happened. That's not what it says. It says we don't have to say this. It could be a false allegation. What they're discussing at that point, whether they should make such a false allegation to Oziel or not. So again, we do not have a clear, emphatic statement in any one place that Lyle Menendez was molested by Jose Menendez. In another page, it says he just wanted to avoid getting into the sex and his molestation in particular at all costs. He did not want to discuss it. So that's the only thing that was off bounds. Again, is this an assumption on the part of Erik Menendez that this is multiple places where Erik says that it happened? So I don't think it's just an assumption. But he says it's an assumption on the part of Erik that he did not want to get into the molestation, or is he saying Lyle Menendez said he did not want to get into the molestation? He doesn't say that. He doesn't say that. And counsel is making that leap that we should read it that way. But that's not what the witness testified to, and she's filling in the gaps with speculation. Filling in the gaps, sorry. Again, if he was molested, if we read it that way, which requires us to take a leap, who molested him? That passage doesn't specify who molested him, and then we get to the another page where it says, he said, with regard to Jose Menendez, why can't you be like your brother? Why do you always have to cry? You're not good enough to be a Menendez. You'll get used to it. Things like that. Once again, there's absolutely no reference to the molestation. I think it's very clear. We get to another page wherein he said, talking about the conversation with Oziel, he said, it was basically ruining my life and I guess Lyle's. And that's where I talk about the molestation and I talk about it, I guess, Lyle's, because I knew that it happened to Lyle in the past. Isn't that him admitting he knew it happened to Lyle in the past? These are multiple occasions in trial where he mentions it. So I don't think it's just a passing thing, and I don't think it doesn't mean anything here, or whatever this prosecutor is trying to argue. Again, is there an assumption or is this something that was said by Lyle Menendez? Well, we don't know because he never testified to that. And since he never testified to that, we do not have a clear, unemphatic statement before the jury that Lyle Menendez said he was molested by Jose Menendez. So, in the absence of such testimony before the jury, counsel should not be permitted to rely upon the fresh complaint rule. I found in the transcript yesterday where it was that the court ruled that the sole reason why it was coming in the first trial was because it was a fresh complaint. It is in volume, well, I believe we mix up the pages here. where immediately following Ms. Bozanich saying that it comes in as a fresh complaint, that it should not come in for the truth of the matter asserted, only to show that a complaint was made. The court then ruled all right on the theory that it does seem to qualify as a fresh complaint. The court would permit it, not offered for the truth of the matter asserted, but just the fact that the statement was made. So that was the sole ground upon which it came in before. Now, the fresh complaint doctrine provides that such statements are admissible, as the court correctly indicated in the first trial, not for the truth of the matter asserted, but only to rebut the argument that would be made by the prosecution that if there had truly been, or the opposing counsel, if there had truly been an assault, surely there would be a complaint. So it comes in to corroborate. In all cases, it is important to recognize that there is the potential danger of prejudice. Prejudice because the jury might have a tendency to consider the statement for the truth of the matter asserted. Now, in all the cases cited by counsel, they were situations in which there was testimony before the jury, and so the danger of prejudice was very small because you have clear testimony before the jury, which is subject to examination and cross-examination. And in light of that process, the examination and cross-examination process, if you have one additional statement that the person made a fresh complaint to a witness, then the significance of that particular statement can be kept in tight parameters because, after all, it has to be compared in relationship to the other evidence before the jury, which includes the examination and cross examination. What is this guy rambling on about anymore? I don't even know. Here, however, we have a very, very different situation. Here, we do not have the testimony of the complaining witness, and that's how it should be regarded. Because the fresh complaint normally comes up in situations involving sexual assault in which the complaining witness does testify and is subject to cross examination. Here, we do not have the complaining witness taking the witness stand, being evaluated on examination and cross examination, and then just to rebut the argument of the other side that there was no fresh complaint. The jury is then permitted to hear a statement of fresh complaint with a limiting instruction advising them do not consider this for the truth of the matter asserted. It is offered solely not for the truth, but to show simply that a complaint was made. This guy is really trying to change things, change, like revise history and how this case is. Sorry, I lost my train of thought. I was going to say something very profound, I'm sure, and I lost it. It had to do with him being. Oh, my eye is twitching really bad. Sorry. Um, he's saying this is a very different situation. We don't have the testimony. Oh, that's what I was trying to say. He's really trying to force the defense, Lyle's defense, to put Lyle on the stand. He really is trying to make him testify to get some of this stuff in. At least it seems that way. Like they're really trying to limit everything about Lyle because Lyle's not testifying now, so we should just not let any of it in, according to Mr. Khan here. Here, when we do have the complaining witness take the stand, there's a tremendous danger of prejudice here. There is a very strong likelihood here that it will be used for the truth of the matter asserted because we don't have the statement of the defendant clearly and unemphatically stated that his father molested him. In fact, if you compare these innuendos by Erik Menendez in his testimony, the fresh complaint, the so-called fresh complaint here, is actually stronger and more probative than the innuendos by Erik Menendez, which turns the whole rule upside down. The rule is supposed to simply rebut the argument made by the other side that no assault occurred because no complaint was made. In terms of the relative weight of the evidence, the fresh complaint should be the minor piece of evidence and the testimony of the complaining witness that should comprise the substance of the allegation. Here, we're turning the rule upside down on its head, and the fresh complaint that really and clearly expresses the allegation and statement before the jury is nothing but innuendo. So I think that clearly this would be a clear distortion of the theory, the purpose of the fresh complaint doctrine, and it certainly cannot be applied here where there is no clear, not one single unemphatic statement before the jury that Lyle Menendez said he was molested by his father. Ms. Towery says, "May I respond briefly, Your Honor?" The court says yes. First of all, I would note that I have been called technical in my career, but never sneaky. This is a first, and respectfully, I disagree. Ms. Abramson says, "Consider the source." Ms. Towery says, "I respectfully disagree with Mr. Khan's characterization of my argument. I think that Mr. Khan's attempt to characterize the citations to the testimony provided to the court exalts form over substance. He says at one point there's no clear emphatic statement in any one place. There are clear emphatic statements in many places. However, Your Honor, starting with the citation in uh, this volume, in which Erik Menendez is describing his discussions with Brother Lyle in response to the question, "What specifically did you talk about?" And he answers at line 4, etc. Lyle wanted to know, no, that's not etc. ETSEQ. What does that mean? Why did I say etc.? That's ETC. What's ETSEQ? Okay, I looked it up. It's a Latin abbreviation meaning and the following. ETSEQ is how you pronounce it, apparently. And it just means and the following. It's used in legal documents. Okay. So, anyways, he answers at line 4. Lyle wanted to know more of the details of what happened with my father and me, and we discussed. I told him about some more things that my father had done, which was actually involved leaving out certain portions that I didn't want to talk about. I told him it was mostly oral sex. I told him about the knee incident. I told him about many of the threats and was more candid with him about, and told him I didn't really want to tell him these things before. I remember Lyle's reaction to that and getting angry with me on the way down and telling me, why hadn't I told these things to Lyle before? Why hadn't I told Lyle about the extent of Dad's violence in terms of telling Lyle? I remember telling him that I was sorry and that I just didn't want him to abandon me. He told me about, in vague terms, some of the things that had happened to him with Dad and that it had also happened to him for a period in his childhood. Bam. I don't think that's a vague reference, Your Honor. It's a very specific reference of Lyle Menendez telling Erik Menendez in the context of conversation about their father's sexual molestation that Lyle responded to Erik Menendez's statements to Lyle and told him it also had happened to him with his father. He references his father. It's not some stranger. He's not talking about some other child molestation incident. He's talking about his dad at line 22 of that page. So I think that the reference is very clear and very specific in the context. In terms, Erik Menendez went on subsequently in his testimony to make a number of references to that statement by Lyle Menendez to him in which he told Erik Menendez that Lyle had been molested by his father as well. And at another citation, when Mr. Khan was inquiring about whether or not Lyle and Erik Menendez had conversations with Brian Eslaminia about his providing false testimony, Mr. Khan asks at line 5, how did you respond when your brother told you of his plan to present false testimony before a jury?" And Erik Menendez answers, "I told him that the false testimony in front of the jury was not what was focused. I was focused on the fact that Lyle was not dealing with the fact that he had been molested and that he was going to have to talk about these things and that these things were going on, and I wanted him to come to terms with that." Again, that's not a vague reference. That is a subsequent reference to his knowledge based on what Lyle Menendez told him, that Lyle Menendez had been molested by his father. At page 45 something in volume whatever, Your Honor, Erik Menendez again brings up the issue in the context of his cross-examination about the discussions among Lyle Menendez, Erik Menendez, and Dr. Oziel. And when Mr. Khan is inquiring about the October 31st and November 2nd conversations among the three of them, he asks at page whatever, beginning at line 26, Question: Are you saying that on October 31st you decided when you went back in November the 2nd you were just going to play it by ear, see what he wanted to hear, and tell him anything he wanted to hear? Answer: No, we did want to talk about it. It referring to himself and Lyle. We did talk about it since we weren't going to tell him what happened, what were the parameters of things we could tell him, and Lyle said, talk about your relationship with mom and even your relationship with dad if that makes you feel better. And he said, well, he didn't really trust Dr. Oziel, but if it made me feel better, then that's what we could talk about. He just did not he just wanted to avoid getting into the sex and his molestation in particular at all costs. He did not want to discuss it. So that's the only thing that was off bounds. Now, that's Erik Menendez testifying about a conversation between himself and his brother, in which Lyle Menendez specifically says to Erik Menendez, I do not want to talk to Dr. Oziel about my sexual molestation. I don't want you to talk to about it either, about yours either, most in particularly not mine. Now, that, if anything, is a direct reference and again a follow up of the previous testimony in which Lyle Menendez repeatedly refers to the molestation of Erik Menendez. I'm sorry, of Lyle Menendez. Erik repeatedly refers to the molestation of Lyle. Court says okay. Ms. Tari says, can I just point out also, Your Honor, Mr. Khan attacks the citation to volume 265, and again, Mr. Khan is cross-examining Mr. Erik Menendez. And I'd just like to point out that in the context, it's clear that Erik Menendez is talking about molestation when he's referring to his discussions with Lyle Menendez. Mr. Khan asks, beginning at line 1, you said that your brother made great efforts to avoid testifying to the allegations of molestation. His answer, yes. Question, when the time came for him to tell that story to a jury, he told it, didn't he? Mr. Levin says objection calls for speculation. The witness says he told, and the court overrules that. The witness says it was difficult, and I told him that I was sorry that I pressured him into doing it, and I would never do that again. Obviously, that must be a reference to Lyle Menendez's testimony about his own sexual molestation because he could not tell from personal knowledge about Erik's sexual molestation and, in fact, did not. By Mr. Khan, you have had an opportunity to discuss the allegations of molestation with your brother, haven't you? Mr. Levin says objection, it's argumentative and suggestive. The witness says, I don't enjoy. The court says overruled. The witness says, I don't envy talking about those things with him, and I have never personally had a conversation with him about what he did to me when I was a child, referring to Lyle's molestation of Erik when they were children. At line 23, he goes on and says, the things that happened with my father, we discussed that the last week in August, and I don't specifically remember any of the conversations that I have had about this where we have discussed it in detail since. Again, that's a reference to a conversation with Lyle Menendez about Lyle's molestation, which Lyle made great efforts to avoid testifying about. And although that reference is not as clear in context, it was very clear to what Erik Menendez was referring to. So I would submit that Mr. Khan's argument exalts form over substance. I've never heard the term. And I would submit that Erik Menendez did in fact testify that Lyle Menendez told him that he was molested by his father. And that was greatly relevant to many of the decisions and the actions of the brothers, which culminated in not only the killings of their parents, but also in the making of the December 11th tape, the relationship with Dr. Oziel, and the Brian Eslaminia letter. It's clearly relevant. It's clearly not only admissible, but admitted. It's before the court, and we should be entitled to present evidence of the prior consistent statement of Lyle Menendez at age 8 to forestall the inevitable prosecution argument that the molestation of both Lyle and Erik is fabricated. And again, Mr. Khan has stated to the court that that will be and is the people's position. They think that molestation didn't happen. In terms of there being no direct testimony by Lyle Menendez, I would submit to the court that evidence is the same as testimony, and if the evidence is before the jury, then we are still entitled to disabuse the jury of the false assumption that the incident did not occur because a complaint was not made. And that clearly is the holding of the Brown case that I cited to the court, that the jury may come to the erroneous conclusion and may, in many instances, be left with an incomplete or inaccurate view of all the pertinent facts if the circumstance of a complaint, whether fresh or delayed, is not provided to the jury so that it can assess the truthfulness of the allegation of molestation. The court says, all right. Mr. Khan says counsel has reread some of the vague references by Erik Menendez, and I don't think they're any clearer now that she's read them a second time. Words such as "it happened to me" was vague the first time she read it and still vague now that she read it for the second time. She cites the Brown case, but counsel has failed to cite a case that is anywhere near similar to the situation that is before the court. That is a situation where the prior statement is being used, or this fresh complaint statement is being used to get the allegation before the jury, rather than a situation where the complaining witness is testifying before the jury, and this is simply being used to rebut the inevitable argument that the abuse did not occur because there was no fresh complaint. So we do not have a case cited by counsel dealing with the fact that they are currently before the court. And to clarify my own reference earlier when I said that I intend to argue in regard to this particular witness that the abuse did not occur, I was referring to the abuse of Erik Menendez because that is what the witness is testifying to. Dr. Wilson is not testifying to sexual assault on Lyle Menendez. He was testifying to sexual assault by not by, but on Erik Menendez. So when I indicated that I intend to attack his allegations or his conclusions concerning the sexual abuse, I was referring to Erik Menendez, not Lyle Menendez. The fact of the matter is, we are taking the same position, or taking the position that currently there is no evidence whatsoever before the jury that Lyle Menendez was ever sexually assaulted by his father. There is none. You guys are such liars. You're so disingenuous. But okay, he's saying there's no evidence that Lyle was abused. And so counsel's theory for offering the fresh complaint fails because if it is used to offer, if it is offered to forestall or attack the inevitable argument that there couldn't have been a sexual assault because there was no fresh complaint, I can assure counsel right now, I'm not going to argue that there was no sexual assault. I'm going to argue to the jury that there is no evidence whatsoever before the jury that Lyle Menendez has ever been sexually assaulted. So it's not going to be a question of, since there was no fresh complaint, therefore we should disbelieve the sexual assault. To the contrary, there's no evidence of sexual assault before the jury. So the very purpose for which the fresh complaint is normally offered does not apply here. Miss Towery says, "Could I say one brief thing, Your Honor?" "Sure," says the court. Miss Towery says the Brown case also discusses the Evidence Code Section 352 issue, which Mr. Khan raised in his prior argument. And in dealing with that issue, the Brown court, or the Supreme Court, indicated that in order to avoid the risk that the jury might use under the fresh complaint doctrine, the evidence for the truth of the matter, that the court should limit the evidence of the complaint to the facts of the disclosure and the circumstances surrounding the disclosure, that should not permit evidence of the details of the underlying molestation to be testified to. I mentioned that in response to Mr. Khan's 352 argument, and I also would like to suggest to the court that we don't have that problem here because no details were provided to Diane Vandermolen by Lyle Menendez. He simply did give her the fact of the molestation by indicating that his father, was touching him in the genital area, but did not give any description of details as to any further conduct. So we don't really have the need to eliminate any portion of the statement by Lyle Menendez, but I did want to point out to the court that that issue was considered and dealt with in Brown. The court says, okay, let's go through the proposed testimony of Diane Vandermolen in the sequence it was presented to me. This relates, first of all, to the offer by Ms. Abramson. The reference by the defendant, Erik Menendez, in 8283 to being so called the hurt man, if that is offered without reference to specific incidents or injuries, but just in general, then it would be corroborative of the defendant's testimony. His testimony didn't relate to specific actions, so just the use of the word would be corroborative if that is the offer. That's the offer, says Ms. Abramson. The court says the reference by Jose Menendez to injuries sustained by Mrs. Menendez as a result of accidents, I don't find there's any relevance in that. If there was any probative value, it's both totally outweighed by its potential for confusion of issues and prejudice. Regarding nightmares and seeking protection from Lyle Menendez by Erik Menendez, I don't know if I don't know what it is that she knows about. Nightmares, the specifics of nightmares, they were described by the defendant and by Dr. Wilson, but I don't know if she has any knowledge of what these were. It's unclear to me what she would say. Ms. Aronson says no. The point here is to corroborate that Erik Menendez, two things: that he was experiencing nightmares because he complained of them to her, that he was fearful of going to sleep without the room being checked, and that he asked her to have Lyle come back and check it. Now, that's corroborative of a number of things. The fact that Erik Menendez was having nightmares, the specifics of them, or the contents of them. I believe Erik Menendez testified to in limited fashion, and Dr. Wilson will be talking about them. But it also corroborates Erik Menendez's testimony about needing to check out his room because of fear that the creature from the nightmares would be in. And that rather cruel that rather cruel trick that his parents played on him by placing this green fright mask in his closet. So it corroborates. The court says she has no knowledge of that. No, not of that specific incident. She just has knowledge he was fearful. He wanted his room checked and he asked Lyle to do it, which I think is circumstantial evidence that he didn't trust his mother and father to do it. The court says, all right. This again relates to symptoms described by Dr. Wilson. Exactly, says Ms. Abramson. The court says, so to the extent she described he complained of nightmares and was concerned that the room be checked is relevant as to who checked it and or what he wanted to be done, who not be or would not be. What do you say? Okay, so what he wanted as to who checked it and or what he wanted to be done. So the fact that it was Lyle versus his parents, he says, is not relevant or probative. I disagree with that. Ms. Aronson says, I think it does also go to the fact that he looked to his brother for assistance and protection, and that's relevant to the events of the week of August 20th. The court says, I find these events are so remote in time they have no relevance other than the symptomology of nightmares that have been referred to by Dr. Wilson by the defendant and by the defendant. So it will be limited just to that purpose only. The same with the proposed testimony that Lyle Menendez would take blame for various incidents. That's not relevant. It's remote in time and there's no probative value. As far as running away and taking the canoe, has that been described by the defendant in his testimony? Yes, says Ms. Abramson. The court says, and she was present when this occurred? Yes, says Ms. Abramson. All right. To the limited extent that even though it is remote in time, it does tend to refute over the length of time of the prosecution's theory that he never tried to get away from an abusive situation. It's corroborative of the defendant's testimony. It has relevance and therefore it would be received. The relevance about Kitty Menendez's rages, hating the defendant and wishing he weren't born, that's pure psychological abuse. It has limited probative value. Ms. Abramson says that's not what it's offered for, Your Honor. The court says, what is it offered for? It's offered to corroborate, says Ms. Abramson, the defendant's testimony that she said that Thursday night before the homicides, as I explained to the court yesterday, this was a common statement that the court says, this is the last witness that will be testifying on this subject. Indeed, says Abramson. The court says, okay, I'll permit it. Ms. Abramson says, thank you, Your Honor. The court says, with the understanding that nobody else is being brought in for that purpose. Right, says Ms. Abramson. The court says reference to Erik Menendez going to his room and Jose Menendez going and saying, and Erik Menendez coming down and looking withdrawn or things of that nature, that tends to corroborate the version of events described by Erik Menendez of sexual assault during that time period, and the court would admit it. The so-called quizzes at dinner, there's no probative value in that. It's irrelevant, and under 352 of the Obedience Code, it would be excluded. As far as the fact that the defendant has no friends other than his cousin for that limited purpose, that would be admissible. That's referring to Erik Menendez. It relates to the testimony of Dr. Wilson. Showering together, that is a continuation of testimony brought in through the testimony of Mr. Andersen, and in regard to Erik Menendez, I'll permit it. As far as the defendant sleeping with Mr. Menendez, I don't see that relates to anything in this case. There's no allegations of molestation. During those occasions, no evidence of it. It's totally irrelevant. That Mr. Menendez would sit with the defendants and talk about Roman soldiers, that again doesn't prove anything. It contradicts the testimony of the defendants as to what those conversations related to. The fact that they might have had some conversations on other occasions doesn't prove anything. Miss Abramson says, no, I think what it has to do with is Erik Menendez testified that his father used these history lessons about the Romans and the Greeks as a way to make the child believe that the sexual activity was normalized. The court says yes, but she doesn't say that that's what she heard. Miss Abramson says obviously not, but she does. She can at least corroborate that Jose Menendez frequently, consistently talked about Roman culture and the Roman soldiers and how they would model themselves after Romans. So it has some corroborative aspect. The court says, I don't see any relevance or probative value in that. It would just tend to confuse issues. The defendant, Erik Menendez, crying when frightened has limited probative value. There's a whole series of questions of the defendant as to his habits of crying and not crying. And there's been some reference to that during the testimony of Dr. Wilson. I'll permit that limited evidence. I don't see whether or not Mrs. Menendez allowed the witness to comfort the defendant has I don't see whether or not Mrs. Menendez allowing the witness to comfort the defendant has any probative value, just the reaction of the defendant and how he behaved, his fright and crying or his response to fright, which would be irrelevant, but just that. Or would be relevant, but just that. The drilling of Mrs. Menendez to keep family secrets about poor grades and school performance and things of that nature, I don't see that as having any relevance to the issues in this case. Ms. Abramson says, well, I think that we're not talking about keeping the secret that the family had molested Erik Menendez. Anybody looking at that objectively would say that's a secret that somebody wouldn't want to have disclosed. Now, that's simple, easy to understand. The fact that somebody had other secrets or things that were kept from the family, that fact, if it is a fact, doesn't prove or disprove the fact or the state of mind of the defendants that they believed the parents didn't want the molestation of Erik Menendez disclosed. Ms. Andersen says, I think it's a little bit the connection, which I believe is relevant, is the inference to something else, Your Honor. It doesn't go to why they didn't disclose molestation because I think the court is right. We already know kids don't do that. It goes to why they thought their parents were capable of killing them, that over the course of their life, their parents had drilled them with great severity. These weren't tips. These were orders to keep even things like not great school performance or not great tennis performance a deep dark secret. That they were extremely concerned with appearing perfect. Given that history, the notion that their sons would reveal something as truly scandalous as sexual molestation, given their history, impressed upon my clients his state of mind that they would kill. If they were willing to punish and drill and be severe about minor things, they would kill to keep this a secret. And that's the relevance. The court says, okay, I understand your argument, but I don't see that is relevant on that issue. I don't see it's probative. Baloney, get out of here. She says, I think it also has some bearing, Your Honor, based on the way that my client was cross-examined by why didn't you tell and why didn't you talk and why didn't you report? even these other things that he was drilled into not telling the truth about. And the other thing is too, this broad accusation of lying that's been levied at my client. Why didn't you tell the police? Why didn't you tell your family? Why didn't you tell your friends? And I think the fact that they were drilled to lie and drilled on secrecy their whole life, and it wasn't just sociopathic tendencies on their part that made them lie. It's important. This is a family that encouraged lying. That's a really good point. The court says, well, again, this isn't encouraging lying. It's just not disclosing things that are secret. Miss Abramson says no, because then they would go to the family gatherings and hear the parents lie about the children's achievements and performances and other things about the family. And the children, of course, including this witness, would never contradict. The court says, okay. Well, my view is under 352 of the Evidence Code, the probative value of this is presented here is substantially outweighed by its potential for prejudice and confusion. Similarly, the fact that Jose Menendez controlled conversations in the home, that was offered as a reason why the defendant never disclosed the molestation. I don't see that as probative of this issue at all. Ms. Abramson says, no, that's not what it was offered for. The court says, that's how you told me yesterday. I think maybe I was speaking too quickly, says Ms. Abramson. Mr. Khan cross-examined Erik Menendez on why couldn't you just go talk to your parents about this problem? He was talking about during those 4 days of crisis, why didn't you just say, hey, we have to talk about this? And my point is to show that in this home, as my client was growing up, he never had the opportunity to have a conversation of this, of any type, with his parents where he selected the topic. And to try bringing up an unpleasant topic to his father was made impossible by his father's reaction. That it was the parents who dictated what was said and what was done and how things were done and what was discussed. And I think this witness would also say how silent and totally non confrontational my client was in dealing with his father or mother. So I believe it shows how ludicrous was the situation that was objected to and overlooked or overruled. Or, I'm sorry, let me start that over. So I believe it shows how ludicrous was the suggestion that was objected to and overruled of Mr. Khan that this was a matter where you could just sit down and have a nice, rational conversation with your folks. The court says, all right, perhaps the demeanor of the defendant when the parents were there and when they weren't there, that's a separate issue. But as far as Mr. Menendez controlling conversations and his behavior in that regard certainly is not probative on the issue of why the defendant did or did not confront the parents with during the week of August, that week before the killings. Clearly, if the whole scenario played out as described by the defendant, his reasons for not confronting his father went well beyond and were much differently motivated than the fact his father controlled the conversations. I don't see any probative value in this. How? It's a case of child abuse and control and manipulation and coercion and the manipulative things that Jose and Kitty would do, you're not going to let in. That makes no sense. Ms. Abramson says, what about the fearful demeanor that she observed? The court says the fact that their behavior was different than when the parents were there than when they were not there, I think that has some relevance specifically if she describes it as different behavior when the parents were there than when she was alone with them. Mr. Khan says, is the court putting a time limitation on this issue? Is the court saying that the witness can testify to differences in appearance and behavior for all of the time that the witness was there in 82, in 76, and through 79? Ms. Abramson says, I'm focusing only on 82 and 83 at this point, Your Honor. The court says, okay. You're saying that during the entire time frame, she will describe the behavior of the defendants being different when the parents were there than when they weren't there. Yes, specifically when both parents were there, says Ms. Abramson. When the father was there versus when they were not there. But even different when the mother was there versus when she was alone with them. that there was a gradation in tension and apprehension and anxiety when the father was around that was at its height. The anxiety was at its height. And when the mother was around, they displayed, or my client displayed, anxiety and tension and apprehension. But when neither parent was around, both of the children behaved differently, more relaxed and happier, and freer with conversation and willing to talk about their ideas and thoughts and feelings. So it's a marked difference in her recollection. And of course, the time she remembers best is the longest time, which was the 13, 14 months of 82, 83. Mr. Khan says, I think we run into the same problem of each and every area that we're talking about here. If we're talking about nightmares, are we dealing with nightmares 13 years before the crime? During that visit, nightmares 12 years before the crime, nightmares 11 years before the crime, 10 years before the crime, or was it during the 1 year visit in 83? Miss Abramson says, I'm talking about. Mr. Khan says, if I may finish, please. Are we talking about 7 years before the crime? I was going to ask a question. Mr. Khan says, Kitty saying, I hate the defendants. Are we talking about 13 years before the crime or 7 years before the crime? In regard to the defendant saying, hurt man, called me the hurt man. Abramson says, I thought the court had ruled. He did on the hurt man. Mr. Khan says, are we talking about 13 years before the crime? I'm just trying to clarify the court's rules. The court's rules. 13 years before the crime, 7 years before the crime, or each and every time that the defendant said this before before he killed his parents. Showering together, we run into the same problem as long as we're talking about an incident that occurred away many years before the crime and far removed from the crime, then perhaps counsel needs further guidance as to what areas she can go into. Ms. Amerson says, gee, I don't feel the need for any audience. I don't think it would be helpful if Mr. Khan would listen. I think it would be helpful. I don't think, okay, I was right the first time. I don't think it would be helpful if Mr. Khan would listen more carefully since I have indicated on each one of these what time period it is. We're not talking about incidents that cause the crime. We're talking about symptoms, the important things in which is the onset of childhood PTSD. And these are things that support it was in existence even as early as my client being 12 and 13, which would make sure, given what he said was happening in his life at 12 and 13 at the hands of his father. The court says the court is attempting to balance the legitimate needs of the defendant to support the testimony of the expert witness with the potential prejudice and undue consumption of time and confusion of issues of evidence that normally would not have any relevance to events occurring in August of 89. These are items these are limited incidents that will be described by the witness. I don't expect that they will consume a great deal of time or encompass descriptions over extended periods of time of the life of the defendant, but for a limited purpose. And getting back to this description, the offer is the 82-83 time frame in which there was a difference of behavior by the defendant, Erik, when the parents were there versus when they weren't. As far as whether the defendants ever criticized their parents, I don't see that as having any relevance in this matter. Ms. Towery says, why did I say Ms. Towery? Is Ms. Abramson that says, how about complaint about them? How about complaint about them? Since we do have here a motive of hatred and obviously an implied motive of such loathing that they would kill them just to be able to buy Jeeps and Porsches and the like. The court says again, we're talking about a time of 82 to 83. Ms. Abramson says it will be a continuum of behavior because we're being limited. First of all, there's a limitation on just how many people were close enough to this family to know anything because of the isolation that was imposed. So we have a continuum of behavior where we're only allowed to show in very limited ways along the time continuum. And here's someone who lived with them where no one else lived with them this long, knew them better than anybody, can establish that time, and will bring it up to you, to the present, that they never said anything negative about their parents or complained about them. The court says, well, you have their behavior during that time period, which has some limited relevance, as I ruled. I don't see that the criticism of the parents, if there was any or a lack of any, has any relevance. If you're talking about at or near the time of the crime, that would be a separate issue. Abramson says, then I'm going to have to add some witnesses, Your Honor, to the witness list of people who were friends with Erik Menendez, where parents were discussed and he never complained. The court says, I'm not saying that's admissible. I'm just saying it will be a different issue. Abramson says, I'm trying to point out there's no animosity here or hatred or preoccupation with negativity or about his parents. The court says, right. But at this point, I'm dealing with this offer. Ms. Abramson says, all right. The court says, if you have somebody else that is going to come in and say something different, I'll have to consider that when you produce that person as to its relevance or admissibility, I'm not ruling that it would be admissible. I'm just saying this is so remote that it wouldn't have any relevance. That Mrs. Menendez threatened Erik Menendez with reports of transgressions. Mrs. Menendez threatened Erik Menendez with reports of transgressions, and his reaction, I don't find that has any relevance or probative value. That Mr. Menendez threatened and pretended to be a burglar. His behavior during that time period, again, I don't see how that is relevant. It's psychological fear. He doesn't see how it's relevant on any issue in this case, whether it's the mental state of the defendant or the opinions of the expert. I just don't see how that has any relevance. It's a remote act, he says. Ms. Andersen says it's considered terrorizing behavior and shows a willingness on his part to keep them frightened of him. Court says, I conclude that from the offer here that it's unreliable character evidence. How do you know it's unreliable? Maybe it's very, very reliable. The court reporter says, Your Honor, could I ask you to turn on your microphone, please? He says, sure. She's been typing away this whole time without his mic on. Okay. The court says, I don't find there's any relevance to Mrs. Menendez's drinking habits or driving habits driving that time period. It's remote in time. Ms. Abramson says, well, it does corroborate my client that she drank and she was fighting to him even as a child because of the drinking that he had a lifelong fear of her because of her erratic behavior, and that was tied to the drinking. The court says, I think this is remote evidence and irrelevant. Abramson says, Your Honor, on the other hand, I can understand weighing and not wanting character evidence of the victim on the other hand. However, glorification isn't accurate either. The court says, no one is glorifying, Ms. Andersen says, to hide the fact that she drank. She drank her whole life, and this is not arcane. Living with an alcohol abusing parent is by itself a form of child abuse, but more once than, but more important. Where did I get once? I have no idea. My brain is shutting down. I need a break. Let me go stretch. We'll come back right here. Start the paragraph over. All right, back to it. Ms. Abramson says to hide the fact she drank her whole life and this is not arcane. Living with an alcohol abusing parent is by itself a form of child abuse. But more important than whether it is to be labeled that or not, it has serious consequences, particularly on the anxieties and fears of those children. To have a parent whose mood swings the way that people who drink all the time do. Court says, okay, again, we're talking about how all of this relates to the mental state of the defendant on August of 1989. Your Honor, all of it is relevant because it's how they grew up. It all forms their relationship, their opinions about the relationships of their parents and how they form relationships to begin with at all, because it's such a dependent relationship on their parents. It's all relative and very important, but he thinks it doesn't relate to mental state, whatever. Sorry. This is very remote, and it's anecdotal information and its probative value, whatever it is, as you've described it, as Dr. Wilson, is substantially outweighed by its potential for prejudice and confusion of issues. Ms. Abramson says, I recall, Your Honor, in many cases and situations, not specifically this one, when prosecutors tended to make an argument, gee, we need it, we're making a we need it argument. Let me just posit this to the court. My client claims he was afraid of his mother and afraid that she would kill him, and afraid that she was both capable of doing it in her own right for her own hatred towards him and as an accomplice to his father. And anything in the background, I will submit that I mean not anything she ever did, but anything that, in the opinion of expert witnesses, and there have been 6 actually who have reviewed this case, that has a linkage with creating a sense of fear of the parents, I would submit is relevant. There are no big smoking guns here, no pun intended, with respect to Mrs. Menendez, and I don't think there's any doubt that the most difficult task for the defense in this case is to convince the jury that it is plausible that my client was afraid of his mother. So I'm asking the court to consider. Yeah, I can't think. Yeah. Number one, how important is it to corroborate my client on the thing that is in his mind led to his mother appearing unstable and frightening, but more important to corroborate him when he has been attacked, his credibility has been attacked on the issue of cross-examination, when the fact that she drank was the subject of the usual sarcastic and sneering and smiling and yelling cross-examination of Mr. Khan, where he was suggesting that Erik Menendez was lying when Erik Menendez testified that he believed his mother drank every day. Here is a witness who can testify that his mother drank every day. And really, that's the only significant aspect of the testimony. That's all that we care about getting in. She drank every day, just like he said. The court says, all right, again, this is the time frame. It's remote, and I just don't see it's probative of any issue. If the issue was she drunk on August the 20th, 1989, you wouldn't be receiving evidence of she had a habit of drinking in 82 and 83. So I just don't find it to be probative as her observations, or as far as her observations, I'm sorry. Mr. Menendez holding the defendant underwater and his physical reactions to obviously subject to limitations as to what she actually saw versus any conclusions or opinions she might have formed is corroborative of the defendant's testimony of those events and would be received. That she said that Erik Menendez, that she had received some statements from Mrs. Menendez as to what had happened, and falling into a glass door or how the glass door was broken is hearsay and is inadmissible. As Abramson says, well, she can testify that she knew that that particular sliding glass door didn't work properly when she lived there. The court says, in what way didn't it work? What does that prove? It didn't. Well, never mind. The court says, it's kind of hard, says the court. Ms. Abramson says the glass had been replaced, but the frame was still bent, and that's why it didn't slide properly. The court says if she can describe that there was a broken frame without relating all the hearsay that might have given it significance to her, it would have some relevance, but everything else is hearsay. So stupid that you can't bring in hearsay of the dead. Ms. Abramson says, all right. The court says, so I don't know who she's going to connect it or how she's going to connect it. Ms. Abramson says, I'll ask what the problem was with the door and see if it's worth doing. The court you also referred, I assume, during this 82 and 83 timeframe to punishment of Erik Menendez behind closed doors. How does she know that? Ms. Abramson says, oh, because, that the court asked, you referred to her. Okay. It looked like she was still talking. Apologies. Um, the court asked the question about the 82-83 timeframe behind closed doors. Ms. Abramson says, oh, because she knew when they were being punished, when they were going to their room and Jose Menendez was angry and was going in there to deal with them and the door would be closed. And she knew not to go down there. And in fact, at this time, of course, the family is living in Pennington and it's the third floor where the bedrooms are. And the rule in the house was you don't even go up to the floor if Jose was up there in one of the boys' rooms for any purpose, but discipline as well. The court says, how does she know it was for discipline? Miss Abramson says, because he would grab Erik and drag him in there to punish him. He would indicate, she'd hear the conversation about high crimes and misdemeanors, and he'd be going in there to deal with it. This is where she made the observation of the belt when she is living at the house at the time. The court says just a corroborative evidence of the testimony of Mr. Andersen and the defendant, Erik Menendez. It will be received for those purposes. The so-called intense discussions between Mr. Menendez and the defendants, I don't find any relevance in. She saw them talking seriously about different things. Ms. Andersen says, well, in the physical intimidation component of it, that's relevant, Your Honor, that he would sit that close to and stare intensely at she saw this going on starting in 78, fairly young children, and would demand and get their attention for up to 2 hours at a time. It's the familiar presence, the intimidating presence that's significant. The court says, well, I just want to interject and say the court knows all this. The court sat through a whole first trial and learned about the effects of abuse. Apparently, he wasn't paying attention because he wouldn't have all of these issues with it coming in otherwise. With this, the things that she's offering are perfect examples of abuse, but the court is like, it's too far in time. I can't see that as state of mind. Well, it doesn't have to be state of mind at the moment of the crime necessarily if it can contribute to the way that they viewed that person in their life. If you grew up battered and bruised by someone, you're always going to be shying away from them and fearful of them, right? So it does go to their state of mind when you look at the big picture, but he's failing to do that because he doesn't understand abuse. Or he does and he's trying to play dumb. That's the other part of it as well. Maybe he does know, he remembers from trial 1 and he's just trying to make it harder for the defense to put on a defense about abuse. Ms. Abramson goes on and says, and controlling aspects of that. The court says if that's her conclusions from the fact the father was having conversations with his son that it's intimidating, I don't see that has any probative value in this case. Again, it's remote in time. As to offers by Lyle Menendez, Ms. Andersen says, Your Honor, one thing that we haven't covered yet that is important. Yes? Ms. Andersen says, is the combination of physical and verbal abuse that the witness routinely saw Mrs. Menendez inflicting on Erik Menendez, where these tutoring sessions turned into episodes where she was hitting him, screaming, and hitting him. The court says that this is a significant thing for Dr. Wilson? Yes, of course it's a significant thing. Of course, you moron. Sorry. Yes, Your Honor. It's really the only observed physical abuse by Mrs. Menendez, and it's out of control hitting. The court says this is an 82, 83. Yes, Your Honor, it's only 83. Court says that is the significant component of Dr. Wilson's diagnosis. Yes, all right, then I'll permit that. You see how he has to verify, well, that's Dr. Wilson's, Dr. Wilson is heavily relying on that. Okay, then I guess I'll let it in. It's like, no, you should be allowing it in because they need it. Like she said, they need it. This is part of the abuse. This shows a pattern of the abuse, and it's important moments in their childhood that led to how they viewed their parents at that moment in time of the crime. Anyways, to Lyle Menendez's offer of proof that Mrs. Menendez was reading his letters, I don't see any relevance to that at all in this case. I've heard the arguments offered, but I don't see how it's relevant. Again, the behavior of Mr. Menendez pretending to be a burglar and the reactions of those inside the house with the defense efforts trying to connect that to the behavior of Lyle Menendez in 89, I don't see how they connect. I don't see any relevance to that. This is a remote act. Ms. Towery says, can I, Your Honor, just to make the record clear, I don't know if this will change the court's view of the evidence. He says, yes. Ms. Towery says, as a further offer of proof, the witness would testify that the three of them, Diane Vandermolen, Erik, and Lyle, were in the house alone when someone began banging on the door and seeking entry, and they were terrified. All three of them were terrified and didn't know whether to remain in the house or try to run away. And finally, Diane Vandermolen and Erik Menendez cowered behind Lyle Menendez. Diane was the older one, right? But Lyle was the man. So they cowered behind Lyle when he got the gun from the closet and sought to preclude the intruder from entering into the house. This wasn't just a, hey, Halloween prank or something cutesy. It went on for a prolonged amount of time. They were extremely fearful, thought that their lives might be in danger, and they went as far as getting the gun out of the closet to protect themselves. And Jose Menendez, Lyle Menendez actually put his shoulder up against the door because the door started to open and tried to keep the intruder from pushing the door open. So it was a physical struggle in which Jose Menendez was opening the door and pushing against Lyle's shoulder. And when he did enter and they discovered that it was Jose Menendez and not an intruder, Jose Menendez laughed at their terror. He made fun of them for it. So I would offer that as an additional description of the incident and ask that the court reconsider its ruling. This was like a very malicious thing that he did. It wasn't just some little tiny prank. I would ask the court to reconsider its ruling on the ground that such an incident would certainly be fear-inducing with respect to both Erik and Lyle and the witness, that relates to their father, that he would be willing to terrorize them in this manner to such a degree that he would actually physically pretend to be a burglar and make the children believe that he was trying to break into the house. The court says, didn't they then realize it was all a big joke? So what does that prove? That they realized the father was willing to play games? It was a big joke? Is that so terrorizing after the fact, looking back on it, really? Says the court. Are you kidding? The court's like, it was just a joke. How's that terrorizing? It was a big joke. I'm sorry, but no. The fear, it might be a joke, but that fear was real. The dad might have thought it was funny. The parents might have thought it was funny, but that fear was real. And I'm sure if you ask Erik, Lyle, and Diane, they would all say, yeah, it was very real to them. But the court says it's just a joke. Is that so terrorizing after the fact, looking back at it? Really? Dad, you did that? That's so bad. Why did you do that? Ha ha ha. That's basically the end result of that whole incident. Ms. Towery says, well, I would characterize it as terrorizing and not as a joke, Your Honor. There is a line. The court says, I have the impression you're trying to depict here that after that incident, everyone walked around the house in terror of Mr. Menendez because of that incident, and that everybody was quaking and shivering for days after because it was such a traumatic event. The impression I have is it was a joke. What a fucking dickhead. Wherever you are, sir, I hope you're rotting because you know nothing about abuse. Wow. Like, wow. I'm speechless. Ms. Towery says, I'm not suggesting that, Your Honor. I'm suggesting it's a very descriptive incident which enables the jury to understand the reaction of the Menendez brothers to their father. He was unpredictable. He was willing to do this. He was willing to do this type of thing to his own children. And although the court does characterize it as a joke, it was not funny to terrorize children. It is considered child abuse by most experts. And although I'm not suggesting to the court that that's the sole reason that Lyle and Erik Menendez were afraid of their father, certainly it's an example of the kind of behavior by their father towards the sons, which instilled fear in both of them. Court says, okay, I don't find that offer of proof meets the purpose for which it was offered, and I don't find it has any probative value. Therefore, the court's ruling will stand. Similarly, lack of complaint, the court's ruling is not relevant. The Jeopardy games, the court finds that's irrelevant. The fact that Mrs. Menendez said to Lyle Menendez that he should never have been born had ruined her life. How is that relevant? What does that prove? Ms. Towery says, for the same reasons that Ms. Abramson articulated, Your Honor. What was her reason, says the court? Her reason was that it corroborated Erik Menendez's testimony that they had an argument during the last week in which she said similar things. The court says, what's the argument? The three of them, says Ms. Towery. The court says this was a statement that Erik Menendez said was made to Lyle Menendez as well? Yes, says Abramson. The court says, or just to Erik Menendez. Ms. Towery says, I think it was both. Ms. Abramson says, you mean that Thursday night it was made to both? It was made to both. Ms. Towery says, in addition, Your Honor, as I indicated and as Mr. Gessler indicated, we are relying on the testimony of Erik Menendez to corroborate our defense as well. The court says, right. But again, if this was a statement made to Lyle Menendez by Mrs. Menendez, then it wouldn't have any relevance to corroborate Erik Menendez's testimony. Okay, if you verify for me that she made this statement to both defendants on August the 20th, Ms. Towery says, not the 20th. The court says the 18th or whatever day it was. 17th, says Ms. Abramson. The court says, find it in the record that that's what she said. Ms. Andersen says, actually, it's the 18th because it's after midnight. The court says, I've also ruled that the behavior of the defendant in 82-83 when the parents were there versus when they weren't there would be relevant. Ms. Towery says, I'm sorry, did you say relevant, Your Honor? Yes, admissible. I've already ruled that but the family secret discussions, that's not admissible. Washing of hair, let's go to that one, relating to so-called sexual molestation or abuse. What did you see that Mrs. Menendez said she was going into the bathroom to wash her son's hair? Ms. Towery says she would see Mrs. Menendez go into the bathroom and remain there until both Mrs. Menendez and Lyle exited. She doesn't know what occurred? No, she wasn't in the bathroom. There's no evidence in this case, nor the first trial, that he molested her or she molested him in the bathtub. That he molested her? He's a child. What are you talking about, sir? Ms. Towery said, I agree. It's not direct evidence. It is circumstantial evidence of sexual abuse by Mrs. Menendez towards Lyle Menendez. He was 15 years of age when this was happening, and it certainly is an odd occurrence. Again, even though it's not direct evidence. Yeah, a 15-year-old teenage boy does not need his mother to shower. So that in itself is weird. He was 15 when it was happening. It was certainly an odd occurrence. I would submit it is circumstantial evidence, and the weight is something that the jury will have to decide what they think it means. The court says you don't even know if the defendant was in a bathrobe, sitting at the sink, or what he was doing, when she went in. It's total speculation on that. Ms. Towery says, well, the court says you have no idea what the circumstance was inside the bathroom, the door closed. Ms. Towery says, I think the witness would testify that Lyle Menendez would go in to take his bath, and Kitty Menendez would say after he had gone in to commence taking his bath, Kitty Menendez would say, I have to go in to help Lyle wash his hair and go into the bathroom and remain there. I think it would be relatively unusual for him to be washing his hair in the sink, for example, with his mother's assistance at the age of 15. Again, the court's correct. She wasn't in the bathroom. She doesn't know what Mrs. Menendez did, but it certainly is circumstantial evidence of inappropriate sexual conduct by Mrs. Menendez towards her son, and I would submit that that goes to the weight and not the admissibility. The court says, all right, I don't find that it is relevant circumstantial evidence. Of course you don't, sir. It really doesn't prove what it is that you're offering it to prove. It calls for total speculation and it's irrelevant, and under 352, it would be excluded. All right, let's go then to the issue of the statements attributed to Lyle Menendez by the witness in 1976. Ms. Towery says, there was one other matter, Your Honor, that I offered. The court says, yes. Ms. Towery says, and that was Lyle Menendez sleeping with his mother at the age of 15 during the 82-83 visit on nights that his father wasn't home. And that was also offered in connection with evidence proffered by the prosecution that Lyle Menendez stated that his mother sexually abused him. And again, in anticipation of the court's response, she does not know what happened in the bed between Kitty Menendez and Lyle Menendez and cannot so testify. So I would again submit to the court that it is circumstantial evidence of inappropriate sexual conduct between a mother and a 15-year-old son. The court says, well, it's unusual perhaps for a 15-year-old son to sleep with his mother, but that doesn't connote sexual contact. It just shows that they were sleeping in the same bed, and there has to be something there of a more direct nature for this corroboration. I don't see how it corroborates anything that has been presented to the jury. Mr. Harry says, well, Your Honor, I just point out that there was no necessity for him to sleep in the bed with his mother. He had his own room at the age of 15. Right, says the court. Ms. Towery says, and also, both of these occurrences happened during the same time period. That is, in 82 and 83, the hair washing and the sleeping with his mother as a teenager. And I would also ask the court to consider that in this situation, the whole is greater than the sum of its parts. And even though looked at individually, these two separate instances perhaps the court feels require speculation, but together it seems clear that this conduct by Mrs. Menendez towards her 15-year-old son was absolutely inappropriate. And were this a prosecution for molestation of Lyle Menendez, I think certainly such evidence would be permissible. The court says, yes, if Lyle Menendez testified, yes, I was in bed with my mother and she did these terrible things to me, then a witness who comes in and says, yes, I saw Lyle Menendez in bed with his mother would be corroborative of that. I agree. Ms. Tari says, I think if Lyle Menendez testified, my mother sexually abused me, that were this a prosecution, the people would be permitted to show circumstantial evidence of strange occurrences between the mother and the son. That's what we have in this case. Lyle Menendez, through the proffer by the people or the offer of evidence by the people through Jamie Pisarcik, has Lyle Menendez saying, my mother sexually abused me. It seems to me that we should be allowed to corroborate that statement, which the prosecutor clearly will attack as fabrication, by showing instances of circumstantial evidence of sexually inappropriate conduct by Mrs. Menendez towards Lyle Menendez. Guess what the court says? I don't find that this would be such evidence. Assuming your premise was correct to start with, I don't find this corroborative evidence of that. It's anecdotal evidence of some conduct that one perhaps thinks is the normal, but that doesn't rise to the level of sexual molestation. You actually sat through a trial, sir, and you know that Lyle testified to sexual molestation. So whether or not he testifies to it in this trial or not, doesn't matter. And the fact that the state is trying to keep it out so hard and you're trying to keep it out so hard really makes me think that there's something going on between the two of you trying to keep it out on purpose, together, in cahoots, perhaps. He says, all right, let's then get to the issue of the complaint in 76 to Ms. Vandermolen. Ms. Abramson says, Judge, could you hold off for 2 minutes? I've got to run out to the hallway and come back. I just need a 2-minute break. He says, sure. Ms. Andersen says, thanks. Ms. Towery says, we also have, in addition to Diane Vandermolen, Kathy Simonton and Joan Vandermolen present, and we had hoped to put them on the stand today. The court says, having in mind these little mini hearings we have to have, Mr. Levin says, every day more witnesses come in. The line is getting longer. Ms. Towery says, Your Honor, Mr. Gessler has provided me with a citation to the transcript with respect to the things said by Kitty Menendez to both Lyle and Erik Menendez on Thursday night. And that is at page blah blah. And that was at the guest house in the presence of both Erik and Lyle Menendez, in which she said, among other things, "I hate you. I hate you. I wish you were never born. You are the cause of all my miseries." And he went on to testify, and she went into the same types of things that she would say generally when she was like that. The court says, "All right, I think that's a sufficient basis for the evidence, recognizing it is remote." Now, to the issue of fresh complaint, we've had extensive argument on it. I've reviewed the materials, and the court is relying upon counsel to provide the court with all references in the testimony of Erik Menendez to the issue of what it is that Lyle Menendez told him. And I'm assuming, from what has been said here, that you have provided me with everything, bearing in mind that there was testimony over many days of which we flipped back and forth to various subjects, and the court has reviewed all of the materials submitted in that regard. In the first trial, there was the proffer and the opening statement of the defendant, Lyle Menendez, stating that he was going to be a witness and described in detail the molestation suffered at the hands of his father. And this particular witness, Diane Vandermolen, testified in advance of that testimony by the defendant, and it was received for the limited purpose of a fresh complaint, not received for the truth of the matter asserted, but merely to buttress or corroborate the proposed testimony of Lyle Menendez, which was clearly going to occur, and the court, in anticipation of his testimony, permitted the witness to describe the fresh complaint. It is quite clear that if such a statement was received for the truth of the matter asserted, it would be hearsay and would be subject to exclusion unless there was some exception to the hearsay rule. The defendant has argued that there are certain exceptions, such as prior consistent statements, spontaneous statements, and statements of physical state. I don't find that any of those exceptions apply. Figures. I don't find that the foundation has been established for those exceptions to apply. The only basis for admissibility would be on the theory of fresh complaint, and that's why we've had reference to all the times that Erik testified in his direct and cross examination about what it was that Lyle told him. In reviewing all of the material, it is my view that the prosecution's arguments are the correct analysis of the situation. Well, go figure. Dick. With the exception of the characterization of Ms. Towery as being sneaky. Creative, perhaps, is a more appropriate description. Thorough, also. However, looking at what it was that Erik Menendez testified to that was said to him by Lyle Menendez, the only reference really is on whatever page, which said that it also happened to him for a period in his childhood. It's unclear, rather, and vague as to what it was that was being referred to. Are you effing kidding me? Context matters, Your Honor. And it wouldn't seem to me to be the basis for receipt of declaration made in 76 to establish what it was that had happened to the defendant, Lyle Menendez, over that period in his childhood, which is really what is being offered to prove. That whatever it was that he was referring to in his statement to Erik Menendez had occurred during his childhood, and it was a molestation, as he told Ms. Vandermolen. I just don't see that this proves that, and it violates the purpose for which a fresh complaint would be received. I don't see there's a factual foundation for receipt of such a fresh complaint from the evidence received here because there is nothing before the trier of fact of molestation of Lyle Menendez by his father. So you say, but people who read the transcript a little bit differently I kind of disagree with that. The other references in the transcript are really conclusions on the part of Erik Menendez as to the state and minds of Lyle Menendez as to why he did or did not do certain things during a particular time frame. That's Erik Menendez's state of mind, not Lyle's state of mind, and that's really what was stated by Erik as to how he felt as to why his brother was or wasn't doing anything. Those were just conclusions and basically nothing more than that of the state of mind of Erik Menendez as to what controlled him and motivated him. I don't see there's a factual basis then for the receipt of this fresh complaint. There's the additional argument, there's the additional argument made by the defense that Ms. Vandermolen then told Mrs. Menendez about it and she didn't do anything, and therefore that corroborates the defendant's testimony in 89 as to what it was that she said or did. And it seems to me that this was a statement she made to Erik Menendez that she knew and she always knew. There's no reference to knowing or always knowing of anything that occurred between her husband and Lyle Menendez. So what? Ms. Andersen says what it means is she knows her husband's a child molester, maybe an incest perpetrator, or could mean that that's a reasonable inference. If we could prove she was told the same as far back as 76 and recalled that 76 is when Jose Menendez starts to molest Erik Menendez as well, I think that's a reasonable inference that the jury can draw. That having been told that Mr. Menendez was doing improper things with Lyle, she then has a certain amount of information, and that supports the notion that when she tells Erik Menendez later that she's known all along that it should be not just starting with Erik's molestation, but even the father's propensities with respect to Lyle. And one would assume if a mother had been told, if she cared at all, that her older son was being molested and knew that the father was spending a great deal of time secreted in the room of her younger son, she might kind of figure it out. Ms. Towery says, in addition, Your Honor, the grounds of which, with respect to which the evidence is offered, that is, Mrs. Menendez's failure to intervene in the sexual molestation of Erik Menendez, that would be offered for a non-hearsay purpose. It doesn't matter whether or not, Ms. Andersen says true. Ms. Towery says, what Lyle Menendez, it doesn't matter whether or not what Lyle Menendez said to Diane Vandermolen is true. The relevance relates to Mrs. Menendez's failure to act upon receipt of the information and, in fact, the rejection of the information. I would also point the court to volume blah, blah, blah with respect to the events that occurred during the last week. On Sunday, Erik Menendez testified that while he was standing on the balcony and looking down at Lyle Menendez and his mother, beginning at line 27, he testified, I remember hearing my brother saying, "Are you going to let this happen?" And my mother saying to him, I didn't hear all the words. She said, "You understood this family." She said something else. I didn't hear what it was. And at this point, my dad came out of the den and grabbed my mom and said, "Let's go, Kitty," back in the den. So it also corroborates Erik Menendez's testimony as to the statement of his brother to his mother. Are you going to let this happen? After the confrontation about the molestation had occurred. The court says the people's response to this? Ms. Harris says, Your Honor, from what I can tell from what's been said here, there doesn't appear to be any evidence that either of the defendants knew that Diane Vandermolen told their mother this. So it wouldn't have affected their state of mind back in 89. And if it doesn't affect their state of mind in 89, the fact that, well, it goes back to the fact that, or it goes back to the way they were born. We knew about the piece of evidence, which is Erik Menendez thought his mother didn't know, and Lyle Menendez thought his mother did know. Ms. Abramson says, here's why Lyle Menendez thought she knew, because she's standing there when Diane's telling her and she's denying it. Mother is in denial and acting in denial. Ms. Towery says, it goes to the behavior of Mrs. Menendez after being provided with the information as well, that Lyle Menendez was aware of that at that time, and whether or not it's true, it's a non-hearsay purpose. It corroborates Kitty Menendez's failure to intervene when faced with information that her sons are being molested by her husband. Ms. Nahara says, once it was Erik Menendez who testified to his state of mind. It was put into evidence by his testimony. Ms. Towery says it does corroborate Erik's testimony. Ms. Abramson says there's also conversation between the Menendez brothers between her state of knowledge about. Remember, Your Honor, going back to the Tuesday night discussion when Erik Menendez tells Lyle it's been going on all along, and there's a conversation about whether mother knows. At that time, Tuesday, Lyle Menendez believes that the mother does know, and Erik Menendez believes she does not. And then on Thursday night, the mother acknowledges that she knew. Well, obviously, Lyle Menendez had reason to say that, in part at least the fact that he's standing there when his older cousin, Diane, is telling his mother this is happening. Ms. Nahara says, may I respond to that, please? In counsel's argument, they're saying this event in 83, which really is a trivial event, is going to affect his behavior in 89. You're calling it's a trivial event. A moment in time when Lyle tells his older cousin that his dad's doing something to him, and his mom is finally alerted to it, and his mom ignores it and denies it. That's not a trivial event. That is a significant, traumatizing event in that boy's life. That's not trivial at all. I'm sorry, I've never been this pissed before as I am in this particular episode because they know nothing about abuse and its effects. And or they do when they're just being disingenuous and purposely malicious. Anyways, Ms. Nahara says it's a trivial event and it's going to affect his behavior in 89. And I think our position on that is that to allow in evidence such as this or something that can be this potentially prejudicial to corroborate, we don't even know if it will corroborate in an issue. All we know is there was some minor incident in 82 where possibly Lyle Menendez may or may not have heard something about something Diane Vandermolen may or may not have said to his mother. But in any event, wow, she really minimized that one, didn't she? But in any event, they're trying to say this would affect his state of mind in 89. And for that reason, they want to bring in a statement, not for the truth of the matter, but there's no way of guarding against the jury not thinking about it for the truth of the matter and some kind of inappropriate sexual behavior that, quite frankly, I think the jury will put more weight on that than they really should. And for something that corroborates so trivial a point, we think under 352 should be kept out. Ms. Abramson says, Your Honor, we consider Ms. Menendez as knowing about it and therefore being a co-conspirator, if you will, or having complicity in the 12 years of molestation of her children. It was not a minor point. And the fact that Erik Menendez testified that his mother admitted she knew is a crucial fact. It is the kind of fact that's ordinarily impossible to corroborate. Yet here we have a corroborating witness that she was told as far back, and Ms. Nahara has the date wrong, but as far back as 1976, that molestation was going on in their household. It's so rare that you can find that kind of corroborating evidence. I mean, for the purpose of the Erik Menendez defense, we have no objection to the jury being instructed that they are not to assume that the evidence that the molestation occurred, that it's being offered solely to show that the transmitting of this complaint to Mrs. Menendez and her reaction to it, that's what we want it for. And my co-counsel have other goals, but we have done everything we can in this case to prove our case, including exposing our client to 15 days on the witness stand. And we think it's vital to our defense to corroborate, especially something that's so difficult to corroborate when we do have evidence with which to do it. Ms. Towery says we also offer it as circumstantial evidence of Lyle Menendez's justifiable heat of passion vis-a-vis his mother on August 20th, 89, again, not for a non-hearsay purpose, but as circumstantial evidence of his heat of passion and the provocation preceding that. The court says, okay, as far as Erik Menendez is concerned, this doesn't prove that the mother knew or didn't know about the molestation of Erik. Are you kidding? It proves that the mother knows what her husband is capable of. He's not going to let it in. Which was the issue that arose and blew up according to the defendant's version of the events that caused the shooting of the death of the parents. So I don't think the offer of this evidence meets the purpose for which the defense of Erik Menendez would be presenting it. As far as Lyle Menendez is concerned and his state of mind, it's pure speculation as to what it is that he knew or heard or was aware of in 76 and remembered and was motivated by in 89. And it's So it's so remote in time that its probative value is substantially outweighed by its potential for prejudice. So we'll take a recess here and resume at 10 minutes to we'll have the jury brought over and we'll proceed. Ms. Abramson says, I need a little more than that, Your Honor. I have to go. You realize with this witness, as many of the family witnesses originally interviewing them, just tell me everything you know, and we start cutting it back. And I have to make sure she understands specifically what issues she's allowed to testify to. He says, let's make it 11, but don't want to make it any later than that. Ms. Abramson says, also, at some point this morning, Your Honor, I'd like to get to the issue of Dr. Dietz, and I'd be asking the court to impose some sort of disciplinary sanction against Mr. Khan for violating the state bar rules on a lawyer comment and the kind of things he went on television saying about the witness yesterday. Ooh, that's going to be interesting. And I'd like to raise the issue of whether it would not, at this point, be appropriate to have a hearing with Dr. Dietz before he is permitted to examine my client because he has apparently made up his mind with great specificity, and Mr. Khan has gone public with what it is that Dr. Dietz now opines, although we, of course, have been given no discovery, and it seems to me that we're in a situation where we have a witness so biased he's made up his opinion without ever even seeing my client. So the Dr. Dietz is the guy who the state wants to do an evaluation of Erik. The judge is allowing them to do so, but they were waiting for him to finish his cross-examination and everything until he got off the stand. So now apparently Mr. Khan said some things to the media or something about Dr. Dietz that she found quite biased, and apparently Dr. Dietz hasn't even evaluated Erik and is already opining that Erik is whatever he is. I don't know, whatever he's saying. Court says, certainly gives you good ammunition to cross-examine. What a dick, man. He's just like, whatever the state wants to do, the state can do. He doesn't care. Ms. Abramson says, it does if I can prove it, and that is why I want the biased information now. In other words, I want to know what it is Dr. Dietz told Mr. Khan that made Mr. Khan go on television yesterday and be quoted over and over again saying that Dr. Dietz will prove when he testifies that the molestation didn't happen. Beyond the fact that this is exactly the kind of commentary that the new state bar rule supposedly prohibits, it tells me that this is a charade this weekend of interviews. Court says, okay, let me stop you here. I don't want to short circuit your argument. I'm unaware of any comments Mr. Khan made or anybody made yesterday to the press. I'll hear more about it, but I want to get the jury here so we can start up by 11 and give you time to talk to your witness. Samerson says, okay, Your Honor, I shall return. A recess was taken and they come back at 11:05. The court says, are we ready to proceed? Ms. Abramson says, the witness is still, I think, Mr. Andersen. The court says Mr. Andersen was on the witness stand. Mr. Gessler was asking about rock throwing. Ms. Nahara said, rock what? Rock throwing, says Gessler. Mr. Khan says, I heard Rockwell, and I was like, what? The court says, okay, we have everybody back. The defendants and their lawyers are all here. We'll get the jury out. The jury enters the room and the following is held. So we're going to continue our cross, what are we on? Redirect of Brian Andersen. Redirect. So that was, FYI, almost a 2-hour argument. We're 1 hour and 45 minutes in, and that was a very long argument. And I feel like we didn't get the defense didn't get as far as they should have or needed to, unfortunately, because the court shut them down on some of those arguments. But anyways, the court says the jurors are in the jury box. Good morning, and again, my apologies. The lawyers and I were diligently working for a couple hours here in the courtroom, and if I could know in advance that it would take so long, I would have told you to come in a little later in the morning. And if in the future I get the information, I'll certainly let you know as soon as I do. I continue to get notes from jurors as far as requests for time off, and certainly we're going to accommodate those. My only suggestion to you is similar to what I asked the bailiff to communicate to you. If you could accommodate as much as possible dates so that if one person has an appointment in the afternoon, someone else perhaps can arrange that so they can do it the same time. So, guys, bunch up your doctor's appointments together because this is a 6-month trial and you're in it for the long haul and you have no free time to yourself. That's pretty much what he's saying. And it would help. It would help us. If you would communicate in regard to that, it would help us. So we don't have one person on one day and another person on another day. It creates more downtime for us. But you guys have tons of arguments anyway, so who cares? We'll now resume with the testimony of the witness. Brian A. Andersen Jr. is back on the stand. He goes by Alan, by the way, Alan Andersen, but for purposes here, we'll call him Brian Andersen Jr. The court says we have Andersen on the stand. Would you please state your name for the record? The witness does so. Ooh, I'm getting a hot flash. Hold on here. Sorry about that. I got like a hot flash all of a sudden. That was weird. I'm wearing this heart monitor now. I got a heart monitor from the doctor, so I have to log all these like weird instances that I have. So that was weird. Anyways, okay. So Brian Anderson's on the witness stand. He states his name again. The court says, "I'll remind you, you're still under oath." And Mr. Gessler is doing the questioning for Lyle, for each both Eric's attorneys and Lyle's attorneys get to do cross or direct, I should say. So here is redirect by Mr. Gessler. He says, "Good morning, Mr. Andersen." "Good morning," says the witness. "You mentioned the incident in which the rock ricocheted off the doghouse and struck Lyle Menendez near the eye. About what time of day did that occur?" "Late morning, early afternoon." "And at that time, was it that his mother, Mrs. Menendez, was home?" "Yes." "When did she ask you to get the razor blade to cut it open?" "As soon as she assessed the situation, I was sitting at the kitchen table." "Did you do so?" "I refused." "At a later time, did his father come home?" "Yes." "And at that time that his father came home, did you notice the condition of Lyle Menendez's eye and face?" "It was still the same." "And what was that?" "Severely swollen." "Well, was it closed shut, do you recall?" "Yes." "What color was it?" "Purplish and veiny." "Could you indicate about what area of the face was covered by the swelling?" "The nose area, the entire cheek area, around in the temple, and just above the eyebrow. The whole eye was shut." Geez, that's a bad hit. What was his father's reaction to this?" "He was stunned." "Why did you say that his father then had a conversation with Lyle Menendez?" Or did you say that? "He first had a conversation with me and then directed it to Lyle." The dogs are going to be loud in a second. Hold on. "At that time, when had this conversation with Lyle Menendez, had you been sent to your room or were you still there?" "No, I was still there." "You said something about he got right in his face." "Yes." "Oh, what did you mean?" "He just sat him and Jose and Lyle went in the front room and Lyle was sitting on the ottoman and Jose was sitting in the chair and he was leaning forward." "Jose was leaning forward and he was, gosh, had to be about this close to his face," and he indicates. "Could you hold your hand up again?" "I'd say about this close." Mr. Gessler says he's indicating, Your Honor, about 6 inches. The court says, all right. Mr. Gessler says, show the judge if you would. The witness does. The court says perhaps a little more than that, 6 to 8 inches. How does the court know that? Oh, 6 to 8 inches. He's saying that it's a little, that it's not quite as that it might be a little farther than 6 inches, I guess. Mr. Gessler says, that's how far Jose Menendez placed his face in that of Lyle Menendez? Yes. Did you see how long this conversation went on before you were sent to your room? Sorry. Did you see how long this conversation went on before you were sent to your room? I was there about a minute or two, just very briefly. He was talking to both of us in the same breath. I was standing to the side of Lyle, and Lyle was sitting in front of Jose. At the time that you were sent to your room, were Jose Menendez and Lyle Menendez still in that same position of 6 to 8 inches apart that you've described? Yes. And the conversation that Mr. Menendez was having with Lyle, was that when he was blaming him for having gotten hurt? Yes. Was this type of confrontation, the 6 to 8 inches apart, was that a common way for Mr. Menendez to talk to Lyle Menendez at that time? Objection, irrelevant and beyond the scope of cross-examination. The court says sustained. Mr. Gessler says, had you seen Mr. Menendez act that way to, he said cross-examination, we're at redirect. He can ask whatever he wants. Well, there's rules, I'm sure, with redirect, but it's his questioning, it's not a state witness, so I don't know. Mr. Gessler says, had you seen Mr. Menendez act that way to Lyle before, that is, that close proximity as far as his face? Objection, irrelevant and beyond the scope of cross-examination. Sustained. Mr. Gessler says, no further questions, Your Honor. The court says, anything else? Any recross? Mr. Kahn says, no further questions, Your Honor. The court says, thank you, sir. You may step down. You're excused. So Brian Andersen Jr. has completed his testimony. The witness says, thank you. The court says, okay, we now have the next witness, who I guess is in the hallway. Is that correct? Ms. Abramson says, good guess, Your Honor. Mr. Andersen, would you send in Diane Vandermolen? He says, sure. She says, thank you. So now we've got the direct testimony of Diane. Diane Marie Vandermolen was called as a witness by the defense and was sworn in. The court says, okay, would you stand behind the court reporter, please, and raise your right hand? In the matter now before the court, you solemnly swear, blah, 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 blah. She does. And the court says, okay. Ms. Abramson, would you make sure to talk directly into the microphone because you have a soft voice? Ms. Abramson says, are you related to Erik and Lyle Menendez? It's her first question to the witness. She says, yes, I am. What is your relationship with them? I am their cousin. And who is your mother? Joan. And what's Joan's last name? Vandermolen, Joan Vandermolen. And was your mother, Joan Vandermolen, related to Mary Louise Menendez? She is her older sister, yes. Your mother was the older sister? Mm-hmm. You know there's a family tree chart to the right of you. Can you find yourself on that chart? I'm the fourth child of Joan and Arnold. And that's on the left-hand side of that chart. It shows Joan and Arnold as Joan being one of the children of Charles and May Andersen. Yes. And you're the fourth in age. Yes. And you have 2 brothers and 3 sisters? 2 brothers and 2 sisters. 2 brothers and 2 sisters. There are 3 girls in the family. Yes. Ms. Vandermolen, how old are you? I am 36 years old. And what's the year of your birth? 1959. And in what state do you currently reside? Arizona. Where did you grow up? Arizona. Is that where your parents lived? Yes. And did you spend some time in the last few years living in another state? Yes, I spent 5 years living in Denver. Colorado? Until recently, yes. And do you have any children? I have 2 boys. I don't know if you remember, but Diane was pregnant when she testified in the first trial, when she was on the stand. How old are your children? 11 and 2. So obviously she was pregnant with a 2-year-old. And Ms. Vandermolen, was it your current occupation? Or what is your current occupation? I am a bilingual elementary school teacher. Do you teach in Colorado? Yes. And are you now, Monday, are you going to be certified to teach in Arizona? This coming Monday, I'll, objection irrelevant, have an Arizona certification. Overruled. The answer will stand. Now, when you were a teenager and young adult woman, did you live for any period of time with Jose and Marie Louise Menendez and their 2 children? Yes, I did. And we have those charts. On how many occasions did you live with the family? Did I live with them? I lived for the summer of 76, again in 78 for about 4 months. I was there briefly in 79, and I lived there for a little over a year between 82 and 83. And in 76 and 78, that was your school vacations? Yes. How old were you in 76 when you were there staying with the family? I arrived at 16 years of age and turned 17. What date of birth is in the summer? Or your date of birth is in the summer? She says, yeah, July 2nd. And were you then 18 going on 19 when you were there in 78? Yes. 20 when you were there in 79. 19 or 20. Well, still, my birthday occurs right around the times when I was there. So you're turning away from the microphone. My dogs are barking. Hold on. So what weeks or months were you there in, was it after your birthday or before? It probably was after my birthday, so I would have been 20. She didn't say a year here, or it wasn't included in the transcript. And when you were there in 82, what month did you get there? I arrived June 1st. And when did you stop living in the family home? July 1st of the following year. So she went from June 1st to July 1st of the following year of 83. And after you stopped living in the family home in July of 1983, where did you live for the next year? I lived in Raritan, about 20 miles north. So you remained in New Jersey? Yes. And before you went to visit with the Menendez family in 76, 78, and 79, and in 82, where had you been living? In Scottsdale, Arizona. So after you lived there, left their home in 83, you remained back east. However, yes, I did. When did you leave the New Jersey area? Objection, irrelevant. Court says overruled. The witness says in July, the end of July of 1984. Ms. Abramson says, where did you go to at that point? Back to Arizona. Back to your family in Scottsdale? Yes. Now, this house chart contains several photographs. I want to call your attention to the one that's marked 349D. Do you recognize the house where it says Muncie, New York? Yes. That's where I stayed in 76. And showing you the next house down, the Mill Road house, which is 349 East. Did you spend any time at that house? Yes. That was in the 78 visit. And during that was the summer of 1978? Correct. And at the end of that summer, did the family move? We moved to the Pennington house. I was there until the 3rd week of September. It was sometime before that. And the Princeton Junction house that's a suburb of Princeton, that area, correct? Correct. It's right near about 10 minutes from downtown Princeton? Yes, exactly. Calling your attention to chart 350 in the top photograph, which is 358, do you recognize that house? That's the Pennington house, yes. When you stayed in 78, 79, and 82 through 83, was it all in that house? Yes, it was. And in that photograph, there appear to be trees and woods. Was that house in the woods? It was in a wooded area, yes. How many levels were there in that house? 3. Where were, well, strike that. Did each of the children, Erik and Lyle Menendez, have their own bedrooms in that house? Yes. And on what floor of the house were their bedrooms? On the top floor or the third floor? Where was Mr. and Mrs. Menendez's bedroom in that house? Down the hall from their bedrooms. Same floor? Yes. Did each of their bedrooms, the children's bedrooms, have their own bathroom, or did they have to go out into the hall and share a bathroom? They shared a bathroom in the hall. And was that the same hallway that led to the parents' bedroom? Yes, it is. Was there a master bathroom in the parents' bedroom? Yes, there was a large master bathroom. Okay, now on the second floor of the house, what rooms were on that floor? There was an entryway. There was a large living room off to the side, and then there was a short hallway. There was a green room out towards the front. Then there was a bathroom. I can barely hear you, says Miss Abramson. She says I just want you to name. She says kitchen, family room, living room, bathroom, and the den, extra room. So the room that you call the green room, was that set up as sort of like a den or an office? It went through stages, but yes. Was it ever a guest room? Yes, for my grandma, not for myself, but yes, I know people stayed there. So your grandmother, are you talking about May Andersen? Yes. She would stay at the home from time to time? She came to visit periodically, yes. Did you visit her, or did you visit with her at that home? After I had moved out of the house? Yes. And when you visited your grandmother at the home, is that when you discerned that she was staying in what's called the green room? Yes. And what was on the bottom floor or the first floor of the house? First floor was the basement, and there was a bedroom, which is where I stayed. There was a large carpeted area, like a playroom? Like a playroom, yeah. And then there was some storage area behind that. When you say a basement, you're talking about an unfinished basement or a finished basement. Partially finished. The room you stayed in was equipped as a guest bedroom? Yes. Was there a bathroom there? No. So if you needed to use a bathroom, where would you go? I had to go back upstairs. When you stayed with the family in 76 and 78, did you have any responsibilities with respect to the children? Yes. Ah, that's why. I think that's why they had other cousins come and stay, maybe to watch the kids and to keep the boys occupied when the mom didn't want to be bothered with them. I think that might be why, because I always have wondered, with all the stuff that was going on in that house, why would they ever want anyone to stay there? Why would they allow other people in the home to stay overnight and whatnot? And now I think I have my answer. They had responsibilities with respect to Eric and Lyle. They were basically the babysitters because Diane's older. Brian Andersen was older. So they were basically the babysitters for Eric and Lyle when Kitty didn't want to pay attention to them, which was always. What were your responsibilities with respect to the children at that time? Can you repeat the years that you're asking about? The first two summer visits, 76 and 78. Yes, I got my driver's license that same year, so I started driving the kids to practices and swimming things and also took care of them a lot. So you babysat them. Yeah. Were you with them, alone with them from time to time? Yes. And in 76, did you have any employment outside of the Menendez family home? No, I didn't. Did you? I'll move ahead to 78. When you were there in 78, did you also drive the children to practices? Yes. Did you remain with them when they were being coached or trained in their various sports? Yes, I did. Did you happen every day, or did this happen every day during that summer? 78. It's hard for me to know about as far as 78, if it was every day. Well, not whether you were there every day. Were they taken to practices and training every day? Yes. You didn't take them all the time. No. Did their mother take them? Yes. Did their father take them? Yes. And in 1976, did you take from time to time Erik Menendez to the Ramapo swimming pool? I don't know how you say that. And then I take it that was the community swimming pool. Yes, it was. And I did. Excuse me. Yes, it was, and I did. Did you observe occasions when Jose Menendez was with Erik Menendez in the pool? Yes, I did. Did you observe interaction between Jose Menendez and Erik Menendez in the pool in 1976? Yes, I did. What was going on? What was Jose Menendez doing with Erik Menendez in the pool? He he rigorously trained them in his swimming techniques and which included dunking them under the water and holding their heads under the water to increase their breath span. Is that what you heard him saying? Yes. All right. You have to focus on Erik Menendez at this point. Okay. You saw similar behaviors with Lyle Menendez? Yes. At this point, though, I want you to focus. Do you recall how old Erik was in the summer of 1976? 6. So, do you know his birthday is in November? November 27th. So he would have been going on 6 that summer? Yes. He was born in 1970. So he would have been 5. And right. Well, I want you to focus on 5.5 or 5 3/4 year old Erik Menendez, okay? Okay. Do you have a specific memory of Jose Menendez doing something with Erik underwater during something to him or doing something to him that to put him underwater? Yes, he would grab him physically with his hands and hold his head under the water. And do you recall he also tied his ankles together, trying as a method of keeping him to keep his feet together. Would he be pushing him underwater at the same time that his ankles would be tied together? I don't recall. You recall that as being two separate things that you observed? Yes. Did you also observe anything with regard to Jose Menendez pulling Erik Menendez down in the water? Yes. If his it would be when his feet were tied together and if he weren't keeping them together, he would pull them together. My interpretation was to get his attention. Well, I'm talking objection, motion to strike, calls for speculation. The court says, all right, the reference to her interpretation is stricken. The rest of the answer will stand. Ms. Abramson says, I'm talking about, did you ever see him pull him down to the bottom of the pool? Yes. By his feet? Yes. Now, with respect to, hold on, DOG, he's eating something. Man, puppies keep you on your toes. Yes, the other day when I was recording, the dog got his head stuck in a jar. Today, he's eating the plastic little squeaker thing out of the toy. I can't take my eyes off of him for a second. Anyways, by the feet, she says, yes. Now, with respect to those times when you saw Mr. Menendez pushing Erik Menendez's head underwater, did you see how Erik reacted to that? Yes, I did. He would flail with his arms and legs trying to get back up. Would you see signs of struggle? Yes. Would you see Erik's demeanor after he got back up out of the water? Yes. What would his demeanor be like? Crying, unable to catch his breath, just totally exacerbated. Was he gasping? Yes, gasping. When you say crying, you mean like crying, crying, not crying out? No, crying. And what would Mr. Menendez do when Erik came up crying? He told him that he needed to toughen up, that this is what was going on and he would do it again. Did he do it again, even after the child struggled and cried? Yes, more so. What do you mean by more so? It would intensify. He would do it longer the next time. Thank you. So he'd hold him underwater even longer the next time? Yes. Did you see this kind of behavior between Mr. Menendez and Erik Menendez that summer more than once? Quite regularly. Yeah, I did. Yes. Did you ever see a point when Erik Menendez did not protest or flail or struggle when he was being held underwater? While he was being held underwater, no. Would he start out okay and then as time went on? Exactly, yes. So it was after he had been under for some time that he'd start these struggling. Exactly, yes. Was he being held underwater for a considerable period of time? I would say so, especially for anyone, especially for a 5-year-old. How long would the training sessions at the pool between Mr. Menendez and Erik Menendez go on for? A couple hours. Oh my God. Poor boy. Were there other things that he was teaching Erik Menendez to do with respect to swimming? Yes. And would they spend just a couple of hours at the pool or just a couple of hours doing what you've just described? They would spend a couple of hours going over that, the breathing. That was for the breathing, pro techniques for the strokes and for the kicks. How frequently would Mr. Menendez be at the pool with Erik, as far as you can recall? As often as he could, is how I remember it. Every weekend? Well, and during the week, if he were to get home and it was still daylight. To the best of your knowledge, in 1976, that summer at least, was Erik Menendez participating in any other sports training besides swimming? I don't recall. I recall the swimming. And you've indicated Lyle Menendez would be at the pool also? Yes. Did you ever observe the children, Lyle and Erik Menendez, being free to just play in the water? No. My sister Kathy and I would, my sister Kathy and I would while they were training. So they would play, and the brothers had to endure whatever that is by Jose. So your sister Kathy and you. Kathy and I would be playing off to the side, and they would be in training the entire time. And after the training was over, were they allowed any time to play or did they have to leave? No, we took off at that point. We left. That was it. Whose rule was that? Jose's. Now, you mentioned your sister Kathy. Did you spend some portion of that summer of 1976 at the Menendez home with you? Yes, she did. And she's your younger sister? Correct. How old was she that summer? When I was 17, she would have been 15. And did she leave at some point? Yes, she did. She left early. Was the plan that she was going to be there for the whole summer? She was supposed to stay with me the entire summer, yes, and she chose to leave early. Now, did you have strong feelings about your Aunt Mary Louise Menendez that summer of 1976? Very strong feelings. How did you feel about her that summer? I adored her. Did you return to the home? Well, did you have strong feelings about Jose Menendez that summer also? I distanced myself from him. Did you like him? Objection irrelevant. Sustained. Did you, over time, develop negative feelings towards him? Objection irrelevant. Sustained. Ms. Abramson asks, when you returned to the family in 1978, did you notice any changes in the personalities of the 4 members of the Menendez family? Objection irrelevant. Evidence Code 352. Ms. Abramson says it's foundational, Your Honor. He says, well, sustained to the question. Perhaps you can get to the issue. Ms. Amerson says, did you notice, first of all, changes in Erik Menendez? Objection, irrelevant. Evidence code, whatever. 352. The court says, overruled. Ms. Abramson says, You can just answer that yes or no. The witness says, yes, I did. Ms. Abramson says, and did you notice at that time changes in the way that his mother treated him? Yes. My dog is going crazy and eating my hand. Did you notice at the time changes in the way his mother treated him? Yes. And when you returned in 82 and 83, did you notice a higher frequency of negative treatment on her part towards Erik Menendez? Objection, irrelevant, evidence code 352. I gotta pause. Mr. Khan objects, says it's irrelevant. Ms. Abramson says this is foundational, Your Honor, to the rage information. The court says, okay, perhaps we can just get to that. Sustained. Ms. Abramson asks, did you observe in 1978 your aunt having very dramatic rages that she directed at Erik Menendez? Objection leading. He told her to do that, you moron. The court says overruled. Yes, I did. Ms. Abramson says, and to move ahead in probably 82, 83, did you see the same kind of thing? It was more frequent and it was more intense. Would you describe, if you can, strike this? Did she have rages that were not directly, specifically at Erik or Lyle Menendez? Yes, she did. But with respect to those that she directed at Erik Menendez, would she say things to him during the course of these rages? She said very hurtful things to him. I can't hear you. She said very hurtful things to him. And was that true in 78 as well? As in, this court reporter keeps leaving out the dates. I'm assuming she means 83, 82 and 83. Yes, it was. And was there a pattern to where she said the same kinds of things in 78 as in 82 and 83? Yes. And would you tell us the kinds of things that you heard her saying to Erik Menendez? I wish you were never born, she says. I hate you, dummy, stupid. And when she said these things, what was her demeanor? How did she look? May I demonstrate? Sure. Her fists would be out to her side and her teeth would be clenched and she'd be gritting and yelling and all of her might, with all of her might, and her body would just be larger. Does not translate. Larger than herself. Was it a menacing stance? Objection. The witness says yes. Calls for speculation and conclusion. The court says overruled. The answer will stand. Ms. Abramson says, and when she was doing this, would she move towards the person that she was yelling at? Yes, she would. Objection irrelevant. Evidence code 352. Court says this is in regard to Erik Menendez? Yes. Overruled. Would she move towards him with these clenched fists? Yes, she would. She would come at him. And you indicated the fists were clenched. Would her arms be shaking as you demonstrated? Like this. And her teeth, she would go something like this. Like her fists would be clenched and her arms shaking like that, and her teeth clenched. And I think that's how she described it. Would her arms be shaking as you demonstrated? Like this. And her teeth like this. And she'd be just like, I'm demonstrating it too. Okay. How did you observe Erik Menendez to react? Well, first of all, was his reaction different in 78 than it was in 82? I just remember him cowering when she did this. By cowering, I can't distinguish between the years. I just know that when she did this, he cowered. What do you mean by coward? She demonstrates. You have to describe. He would he would crouch. All right, says the court. The witness says he would move away from her, moving at him. He would like duck. Miss Abramson says, would she necessarily hit him in the course of one of these rages? Yes. Would she always hit him? No. When she did hit him in the course of these rages, where would she hit him? I can't recall, or I can recall her slapping him upside the head. It's hard for me to recall. Apart from hitting, did you ever observe her throwing things at him when she was in one of these rages? Objection, irrelevant, evidence code 352. Overruled, says the court. The witness says, I remember her throwing things, and I don't recall if they were at him or just that they were being thrown. Ms. Abramson says, was it when she was yelling at him? Yes. Can you remember any specific activity that she and Erik Menendez would be engaged in just before one of these rages routinely? Routinely? Yeah. Would be when she was tutoring him. What do you mean by at the dining room table? What do you mean by tutoring him? She very often, I would say probably daily, helped him do his homework, and it would get being frustrated and it would just escalate very rapidly. What would escalate rapidly? Her frustration level. Would she her how would her frustration turn into what you've described? If he didn't get something that she was trying to teach him or tell him, at first, she would just start calling him dummy or stupid. And then, if it still continued like that, then she'd be raging and flipping out. Is that when you saw her hitting him? Yes. On the head? Yes. Did you see that more than once? Yes. How frequently did you see this teaching turning into hitting? A lot. Was this going on in 82, 83? Yes. Did you ever hear in the course of any of this any discussion about about his hearing difficulties or auditory processing difficulties or his dyslexia? Did she ever mention any of those things? No. Objection, says Mr. Khan. The witness says, I didn't know he had them. Mr. Khan says, evidence code section 352. The court is overruled. The answer will stand. The witness said, I had no idea he had any dyslexia or learning disabilities. Ms. Abramson says, and you lived in the house? Yes. And you never asked? Objection. I never knew about it, says the witness. Overruled. The answer will stand. Ms. Abramson says, were you aware that he had been tested to see if he had hearing problems in 1988? No. Objection calls for hearsay, says Mr. Khan. The court says sustained. The answer is stricken. Ms. Abramson says, and strike that. During these tutoring sessions where she's trying to help with homework, could you observe whether Erik was trying, cooperating, doing what she said? Objection calls for speculation. Rephrase the question, says the court. Yes, says Ms. Abramson. What did you observe of Erik Menendez's behaviors when his mother was sitting there getting frustrated? He tried with all his might. How do you know that? Objection calls for speculation. Motion to strike, no foundation. Overruled. The answer will stand. Ms. Abramson says, what did you see? I saw a boy who was really trying to get it, who was trying over and over to get it right. Can you describe his demeanor? Mr. Khan says, I'm going to ask that we take a recess, Your Honor, until this witness can compose herself. Ms. Abramson says, every time a witness gets emotional, he wants to take a recess. He should just live with it. Do you want a recess? Asked the court. I'm fine, says the witness. Ms. Abramson says, do you want some water? Please. So she was getting emotional because she remembers poor little Erik getting abused by his mom, trying to learn, trying to do his best, and she's just calling him dumb and hitting him. And she gets emotional by that. And Mr. Khan's like, objection, let's take a recess. Whatever. Get out of here, Mr. Khan. She just wanted water. Ms. Abramson says, why are you crying? What are you remembering? Erik was a sweet kid. The court says, okay. The witness says, okay. Would you ask the next question, please? Again, Ms. Abramson says, when she was telling him to do things, did you see him doing them? Yes. When she asked him questions, did he try to answer? Yes, he very much tried to follow what he was supposed to be doing. Well, did you hear him ever refusing to go along with what she was saying or doing? No. In addition to those homework sessions, did you ever observe her giving him sample tests or drills that she had with a stopwatch? Yes. Ms. Abramson says, "Do you want some coffee?" "Thanks," says the witness. "Trying to find some Kleenex," says Ms. Abramson. The court says, "Let's ask our next question, please." Ms. Abramson says, "Let me give her something, Your Honor. Do you have that, Barry?" The witness says, "Thank you." Ms. Amerson says, "Did you see that? These drilling sessions different than the homework teaching sessions?" Objection, irrelevant. Evidence Code, Section 352. Sustained. Ms. Amerson asks, "Did you see the same eruptions of hitting by Mr. Menendez to Erik Menendez after one of these practice exams and stopwatch trainings?" Yes, he would do it fast if he couldn't do it fast enough. I'm sorry? He couldn't do it fast enough. And would she hit him when he couldn't do it fast enough? Yes, yes. And then they would repeat. How did you observe? First of all, did you observe Mr. Menendez ordering Erik to his room on any occasions? Quite frequently. Were there two different circumstances as you observed it in the course of which Mr. Menendez would order Erik to go up to the third floor to his room? Yes. Objection leading. Overruled. Can you characterize what the two different circumstances were? Then I'll ask you to describe them. Okay. There were two scenarios in which he would be sent to his room. One would be because he needed to go upstairs to do his homework, with Jose telling him that he'd be up in a while to do his homework. What would Mr. Menendez say? "I'll be up in a while to help you do your homework." He'd send him to his room first? Yes. And then say, "I'll be up in a while?" Yes. What was the other scenario? Where he would be being sent to his room because Jose was very angry at him. How do you know that Jose was very angry at him? He was visibly angry. Was it hard? Very upset. Was it hard to tell when Mr. Menendez was angry? No, it was not. How could you tell? He roared. Your gesturing, you have to describe. He was a muscular man and it was just, he would grab him to the side and send him up. So he would grab him first? Yes. And then send him up? Yes. Did he have a look in his face when he was angry that was different than when he wasn't? He was fierce in his anger. Was that a look as well as a tone of voice? His voice deepened. What about his face? He looked really angry. Okay, and when Mr. Menendez appeared angry and would grab Erik Menendez and send him to his room, what would Mr. Menendez then do? Could you repeat the question? Was it your belief that Erik Menendez was being sent to his room to be disciplined? When Jose was angry, yes. And would Mr. Menendez and Jose would follow him up after a little while. So after he would send him up to his room, he would go up there? Yes. And with respect to those times when Jose Menendez directed Erik Menendez up to his room, saying, "I'll be up in a little while to help with your homework," would Mr. Menendez go up? Yes, he would. Let's focus, if we can, for a moment on those times when Erik Menendez was told to go to his room ostensibly to do homework. Okay? Okay. How long would Jose Menendez was this happening before dinner time? Yes. How long would Jose Menendez stay in Erik's room after spending or sending the child up there ostensibly to do homework? We would have finished dinner and have cleaned the kitchen, and he would be coming down about that time. So he missed dinner to go abuse his child. And would he, Mr. Menendez, say anything about Erik Menendez and dinner at that time? Quite often, he would tell us that Erik was not feeling well and would be down after a while to eat his dinner, or that he would take dinner up to him after a while. And accordingly, after one of those episodes, did Erik Menendez come down to have dinner or eat? occasionally. And when he did come down, did you notice anything about his demeanor? He would be very quiet, very somber, and just pick at his food. Now, this is after everyone else has had their dinner. Yes. So he would be by himself at the table eating. And on those occasions, do you recall whether Erik Menendez's demeanor was somber and quiet when he was first sent up to his room to do homework? Not at all. What would be the difference? When he was on his way up, I mean, he seemed very normal. But when he came down later, a big change, like I just said. And these were the supposed non discipline sessions, correct? Yes. On those occasions when Erik Menendez would be sent up to his room for discipline, where Mr. Menendez was angry, would he emerge at all afterwards? No, I don't recall ever seeing him after he was sent up to his room after that. When he was sent for discipline, how long ordinarily would he remain in his room? I don't recall seeing him for the rest of the evening. So he was there, right, for the rest. And how long would Jose Menendez spend in Erik Menendez's room for the supposed discipline times? A significant amount of time, at least an hour. Sick. And did you ever go up to the third floor and never listened at the door and try to find out what was going on there for an hour? Never. Why not? Especially by the 82 visit, it was just understood that if Jose was doing something with either of the boys, that they were with Jose and that was it. And we were to leave them alone. Okay. Were you to not enter the room or not go near the room or not go to that floor of the house or what? Jose was up with the boys. We didn't go up there. Who's we? Anyone. You and your sister? Whoever was in the room. You and Mrs. Menendez? Yes. So would you even go to the third floor during the 82 visit when they were living in that house in Pennington? Ever? When Mrs. Menendez or when Mr. Menendez was upstairs with either of the sons? No. Did you ever see, so you never, well, strike that. Did you ever see Mrs. Menendez going back to 76, even approaching either of the boys' bedrooms when Mr. Menendez was in there with either of his sons? No. Do you recall a time when Erik Menendez told you about having nightmares? Yes, I do. And do you recall which visit that was? The 82 visit. Do you recall what Erik Menendez told you about nightmares in 82? He was afraid to go to sleep because the monsters were going to get him. Which monsters? I don't know. Monsters from under the bed or monsters from where? They could be anywhere in the room. But where were the monsters? What was the source of the monsters? I don't know. What connection did the monsters have to the nightmares? Oh, because his monsters were in his nightmares, and so if he didn't go to sleep, then the monsters couldn't get him. Did he indicate to you that he thought the monsters could leave the nightmare and be in the room? He had us check the entire room. And what did you mean by check the entire room? Objection, motion to strike, non-responsive, sustain, the answer stricken. Did he express concern about the nightmare monsters being in his room? Yes, he did. And what did he want done, if anything? Objection, irrelevant, sustained. Mr. Khan says, evidence code section, sustained, says the court. Would he demonstrate fear of going to sleep? Yes. How would he demonstrate that? He refused to go to sleep. Objection, all right, you've answered the question. Your next question. Ms. Abramson says, eventually, would he go to sleep? Well, after. Objection, non-responsive. Ms. Abramson says, did you have to look in the doors and the closets? Objection, irrelevant. Overruled. You can answer the question, says the court. The witness says, he had me bring Lyle in to check. Ms. Abramson says, just the answer. The court says the answer is non-responsive. It's stricken. What? Ms. Abramson says, did someone have to look in the drawers and closets? Yes. Before he went to sleep? Yes. To make sure the monsters weren't there? Yes. Was that done? Yes. More than once? Yes. Could he then go to sleep? Yes, after he was assured that there were no monsters in the room. Did you ever see his mother doing that? No. Did you ever see his mother doing that? No. Did he ever ask his mother to or father to do that? No. And at that point, he is in 82. He's going on 12 and then going on 13? Yes. And did you know for how many years? Well, first of all, did he complain to you about nightmares in 78? I don't recall. Do you recall in 82, that year, that 13, 14-month period that you lived there, whether Erik had an unusual nickname for himself? Yes, he called himself Hurt Man. Hurt Man. And did you know why he called himself Hurt Man? No. Objection calls for speculation. The answer is no. The answer will remain, says the court. Are you not paying attention, Mr. Khan? Ms. Abramson says, and how did you know he called himself Hurt Man? He referred to himself as Hurt Man. He says, I'm Hurt Man, or Hurt Man does this, or Hurt Man. Yeah, he would be doing something and refer to himself as Hurt Man. Did you ever ask him why he was calling himself Hurt Man? No. Do you know who Andy Cano is? Yes, I do. I think you can find him on that chart. He is the fifth child of Marta and Peter Cano. And did you understand? Did you know Marta Cano? Yes. Was she related to Jose Menendez? She is Jose's sister. And did you know her children? Yes, I did. In 82, 83, did Marta Cano and her children live in the Princeton area? Yes. And did you see and know Andy Cano even before 83, 82, 83? Yes. Was there a time when you were spending your summer at the Monsey house when Andy Cano was there for a couple of weeks? Yes, for a couple of weeks, yes. Was he very young then? Mm-hmm, very. So I think Andy was a little bit younger than Erik as far as, age wise. So obviously Diane's older than Lyle, then Erik, and then Andy Cano, I believe. So he was under 5? Mm-hmm. Yeah, so he was definitely younger than um, Erik. Is that a yes? Yes, sorry. Was Andy or is Andy Cano younger than Erik Menendez? Yes, he is. Do you know by how many years? I don't. In 82 and 83, did you observe the relationship between Erik Menendez and Andy Cano? They seemed very close. Close friends? Yes. Were there any other friends that you ever saw Erik with? Erik wasn't allowed to have friends. So you never saw any other friends? No. Did Andy Cano ever spend any overnights? Yes, he did. At the Pennington house while you were there? Yes, he did. On approximately how many occasions? As often as Andy and Erik could arrange it. Well, that doesn't tell me. Do you have a number? Many times. And did you ever know of occasions when Erik Menendez slept over at someone else's house? No. Do you remember whether he slept over at Andy Cano's house on any occasion while you were there? No. You can't recall that? I don't recall. Would it have been very unusual for either of the Menendez brothers to spend the night at someone else's house? Yes, it would have been very unusual. Was there a day when I don't think they were allowed to, is what she's trying to bring it out. Was there a day when you were there for the 82, 83 visit when Erik apparently ran away? Yes. Can you describe the events unfolding as you learned them? To my recollection, we realized that Erik was missing, and well, what time of day was it when you realized he was missing? Late afternoon. When you say missing, he'd been gone for quite some time. So no one had seen him for quite some time? Right. And ordinarily, did he stay around the house? And yes, it was very, very unusual. Okay. So then, what was the next realization? Well, we meaning Kitty, Jose, myself, and Lyle. And who? Lyle. Okay. Went looking for him, and Kitty discovered that the canoe was missing. At which point, Jose decided that he was going to go look for him. The assumption was that Erik had taken the canoe. Yes, the canoe was missing, Erik was missing, and the assumption was that they were together. Okay, was this, as far as you can recall, was this a day of ordinary weather? Yes, it was. So not a stormy day. Uh, the weather was fine. And after that, did Mr. Menendez go off? Yes, he left. And sometime later, do you remember seeing Mr. Menendez and Erik? Yes. How much time had, if you can remember? I remember exactly. Okay, how much time after Mr. Menendez had left did you see him again? It was just about dark. The sun had already set, and it was at dark. Okay, do you recall how long he was gone from the time that he said he'd go to find him or get him until it was dark? Do you have an approximation? It would be a while. I guess about an hour. Okay, and when you saw Mr. Menendez, you saw Erik as well? Yes. Can you describe how they appeared? I remember watching them come up the hill from the lake area. Jose was a few yards ahead of Erik, several yards actually. They were both soaking wet. Jose was furious and Erik was crying. Do you know how they had gotten wet? No, I don't. Did they have the canoe? I don't remember. Did they have one boat or two boats at the Pennington house? There was a canoe and then there was something else. Was there a sunfish sailboat? A sunfish. On this occasion, was it the canoe that? It was the canoe that he took. And when you said that Mr. Menendez was furious, how did you know that? Because he walked right past me and he was really upset. You could tell by looking at him? Yes. And Erik was crying? Yes. Was it unusual to see Erik crying when he was 12 and 13? No. And what kinds of things that you observed, what kind of event or act or thing would result in Erik crying from what you could observe? Was there more than one reason why you'd see Erik crying? Yes. Okay. What kinds of things would make Erik cry at 12 and 13? Well, when Kitty would be yelling at him, when Jose would be laughing at him for having given a wrong answer. Laughing nice or no, laughing in a very belittling manner. Okay, what other things would make him cry? Kitty telling Erik that she was going to inform Jose of something that he was doing wrong. And and he would cry, when he said, I'm going to tell your father, things like that, yeah. Would he ask her not to? He would beg her not to. And what was her response? Like they worked out some kind of deal or something. Would they work out a deal? Objection calls for speculation. Sustained. The answer stricken, says the court. Miss Abramson says, and did you see, we'll strike that, any other things that would make Erik cry? When Tristis died. I mean, when his feelings were hurt. I don't know who Tristis is. One of his animals? I don't know. Did you ever see him cry? We'll strike that. When you saw him crying, when Mrs. Menendez would threaten to tell Mr. Menendez something, did Erik appear fearful at that time? Yes. Would he cry? Did you see occasions when he cried from fear? Yes. When his father would be angry with him, did you ever see him cry even if he wasn't being grabbed or thrown in his room? Yes. And this was at 12 and 13. Yes. Did you observe differences or a difference in the way that Erik and Lyle interacted with each other when the parents were there versus when the parents were not there? There was a big difference. Did you observe differences in the way Erik Menendez talked and looked at when his parents were not there versus when they were there? He was, yes. I'm not asking yet what they are, okay? Was there a difference, in fact, in Erik's demeanor and behavior when his father was around versus just his mother was around? A marked difference. And was there an additional difference when neither of them were around as compared to when just his mother was around? Yes. All right. Could you describe? And first of all, we're talking about 82, 83. Correct. Are we also talking about 78? Yes, not as intense. Okay. Then let's focus on the most intense differences. We're in 82. Yes. So would you describe first of all how Erik and Lyle their behavior towards each other was different when the parents were not around? When it was just the three of us? Yes. We laughed and smiled and joked with each other and got along very well. I can't hear you. It was fun. We laughed. We had fun with each other. How did Erik and Lyle Menendez treat each other when the parents were not around? Very competitively. You had to compete for their love. When the parents were not around? When they were not around? No. How did they treat each other when the parents were not around? Exactly the opposite. Well, what's opposite in your mind of competitively? They were buddies. When the parents were around, how did they interact? Very competitively. And was that them trying to compete for the parents, or was it something they were being told to do? Objection calls for speculation. Sustained. Ms. Abramson says, did you hear the parents trying to get them to compete with each other? Yes. Jose made a direct statement to that effect. Well, what did he say? In 76? Yeah, what did he say? That's how you are to raise your children, that's the way to do it. What's the way to do it? Competition breeds success. That's the way to parent. That competition breeds success, breeds success. And were there instances in a variety of areas where you heard each parent encourage each other or each of them to do better than the other? All the time. Did you observe Mr. Menendez encourage Lyle Menendez to physically strike Erik? I don't recall. Do you recall him urging them to box or fight with each other? Objection, irrelevant. Evidence Code Section 352. Sustained. Did you ever see Erik Menendez get physically hurt by Lyle Menendez in the presence of his parents? Objection, irrelevant. Evidence Code Section 352. Sustained. Now, what was the difference between Erik and Erik's demeanor when his father was present versus when his father was not around? His anxiety level was very obviously high. There was a marked a physical difference in his demeanor, almost at attention. When what? When Jose was there. So he was like at attention, like a soldier at attention. He was more tense. His body tenses up. He's stiff. He doesn't want to interact or do much. As he's not going to be as openly, fun and outgoing like he normally would be when his parents weren't there. Could you detect this change? When Jose walked in the door, both boys just stiffened up and came to attention. And would that continue while Mr. Menendez was around, or did it relax after he got home? No, it there was a marked difference between when he was not present and when he was, and it would remain like that. So imagine being at attention for hours and hours on end because you know your parent could snap at you at any minute and you got to walk on eggshells and you just got to be on your best behavior. Was that they would remain at attention with him for the remainder of the evening? Was that true in 82, 83? Yes. Had it been slightly different earlier on? Yes. It was more, had there been some lighter moments in, I don't know what year? Yes, it was more relaxed in 76 and in 78. But you saw no evidence of relaxing around him in 82, 83? Uh-huh. Now, did you see Mr. Menendez spending a lot of time with Erik and Lyle Menendez in 82, 83, particularly on the weekends? If he were home, he was spending his time with the boys. Totally, all of his time? That's how I remember it, yes. And they were spending all of their time with him? Yes. Were they doing sports things? Continuously. Did you see Mr. Menendez spending whole days on the tennis court with Erik and Lyle Menendez? Yes, if he were home on the weekends, they were on the court. And during those long days, did you ever see Erik Menendez relaxing or at ease or non tense around his father? No. When Mr. Menendez was with Erik Menendez on the tennis court, was Erik being drilled in tennis? Yes. Was he working hard? Very hard. Were there sliding glass doors on the first floor, the floor that you lived on, that separated the basement from the tennis court area? Objection irrelevant. Overruled. Yes, there were, says the witness. And was the sliding glass door the main exit from the house to the tennis court? Yes. And in 82 and 83, when you lived there, did you notice anything defective about the sliding glass door? It stuck all the time. You had to really force it. It would jam because of the court says don't say why, just it wasn't working, right? Right. He just cuts her off. There was something wrong with the tracking of it? Correct. Court says, let's take our recess. It's 10 after 12. We'll resume at 1:30. Don't discuss the case with anyone. Don't form any final opinions about it. We'll resume at 1:30. And that is where we will end today. We will continue Thursday with part 74 and the conclusion of Diane Vandermolen's testimony, along with I think we got some arguments with no jury again. So that's where we're at. All right. So thank you guys so much for joining me, reading along with me. It is insane to see how different of a trial it is now. Now that we're getting to the defense's case and all of their stuff is being blocked by the state, I really am seeing a difference in this because one of the key things that Diane Vandermolen testified to, which she hasn't gotten to and can't, because the court ruled it's inadmissible, was when Lyle Menendez confided in her in one of her earlier visits in 78, 76 or 78, that Lyle was being touched by Jose. She told Kitty. Kitty denied it, said, no, he's not. And don't worry about what you're seeing. You're not seeing what you're seeing, type of thing. And then that was that. She minimized it, said, nope, it's not happening, and didn't do a thing about it. That was really powerful testimony regarding Erik's molestation. And they tried so hard to keep it out. And they were successful. The state got it to be inadmissible. The court ruled it inadmissible. And that really sucks for Lyle because he can't get on the stand because of the whole they would impeach him obviously with trying to uh, whatever plans he had come up with to avoid talking about the molestation, which led to, asking people to possibly lie for him on the stand. And that was not something that his defense team felt was something that they wanted to take a gamble with, that coming out in front of the jury. Unfortunately, we don't get to hear about what happened to Lyle then when he was a child. Not in detail. Not really. So that sucks. I have a feeling in the penalty phase we might hear it, but in this part of the trial, when it comes to the guilty, not guilty phase, the sentencing or the guilt portion of it, then they don't. Totally lost what I was going to say. When it comes to the guilt portion, they're not allowed to bring any of this abuse stuff in, or at least everything has become a battle. And he allowed some minor things in, but I don't think her testimony is strong like it was in the first trial. So that would be my one big criticism of this court and this prosecutor, is that they don't understand abuse and purposely are trying to keep it out. The only possible explanation. They have to know that it's not good evidence against Kitty and Jose. But why are we fighting so hard for Kitty and Jose if they're horrible people? I don't get it. Anyways, that is part 73, and I will see you guys in part 74 for the conclusion of this and some more heated arguments. Thank you guys for watching. Take care. Bye now. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.